frequently as possible. Good morning, everyone. This is the convening of the Massachusetts Gaming Commission, and we're holding this meeting virtually, so I'll do our roll call. Good morning, Commissioner O'Brien.
Good morning. I'm here.
Good morning, Commissioner Hill.
Good morning. I'm here.
Good morning, Commissioner Skinner.
Good morning.
And good morning, Commissioner Maynard.
Good morning.
Okay, this is public meeting number 472. We're meeting on Monday, first thing, 9 a.m., August 21st. And we are turning back to portion of our agenda where we had completed much of the presentations, but not all of it. And I think I left it, and I'll let Councillor Grossman, Interim Executive Director Grossman, remind us of where we left off, and I think we'll be turning to the applicant.
Well, thank you, Madam Chair. Good morning to you, to the commissioners, and to all who are joining the meeting here today. Of course, when we left off, the commission had gone through a bulk of the presentations and the presentation of evidence. There was one new piece of information that emerged in the course of the meeting, and time was afforded the applicant to review it, and they have submitted some subsequent supplemental materials that have been circulated to the commissioners last evening, I believe. So at this juncture, I think we'll want to hear about that piece of information, make sure there's no further information to be discussed, because the next step of the proceedings would be to move into the review and evaluation process pertaining to the two issues presently before the commission, which of course, as everyone will recall, are the petitions for withdrawal of the two qualifiers, that being Christopher Carney and the Christopher Carney Subchapter S Trust. And then secondarily, the preliminary suitability review under Section 215 and Chapter 23K of the Commission's regulations and statute as applicable. So those are the issues presently before the Commission. And Madam Chair and Commissioners, if you're so inclined, we could, I don't know if the IEB has anything to say about the document that was forwarded, or if we just want to go right over to the applicant to describe and explain it.
Before we turn to that, I want to make sure it's not, this morning isn't completely restricted to just this document, correct? I believe we're going to allow MGA to respond fully to the suitability report too. And I see Commissioner Skinner, I know you left at the end of the meeting where you wanted to make sure that we heard fully from MGA, correct? So is that fair? I just want to go back to.
Yeah, no, I think that's right. We can certainly allow the applicant to respond. You are right. I think we did leave off without giving them a full opportunity to respond to all the information. So they should be allowed to do that as well.
Thank you. You know, yeah. It was a very long meeting. I want to make sure we don't miss anything. Mr. Nozzle, Attorney Nozzle.
Yeah, Chair, that was our understanding, and we're prepared to address two issues and a few issues within our presentation. Of course, the document that was circulated on Friday, we can respond to, and then also we have essentially some additional information to go through to respond to some of the issues that are raised in the supplemental IEB report.
Okay, great. Thank you. I just want to make sure we clarified that. In terms of IEB, perhaps because the public didn't know what the document is, I think that was your point, Councillor Grossman, to turn to you, Director Lilios, or Councillor Hall on that document that was circulated to us.
Sure, Chair. I can jump in on that. And just by way of explanation, it's not part of the IEB's protocol to pull the Secretary of State's filings on the applicant company as part of the preliminary review. We do verify all of the information on the BED form as part of the full review. We do an independent verification. It was really during the hearing when there was some discussion about something that was disclosed on the BED and then was disputed in the hearing that staff went online and pulled a document from a public filing from the Secretary of State's office that was submitted by the applicant, I think under that 156D that council has referred to. So I did want to just explain how it was that that document came to light at the date, and the filing itself does indicate a couple different things. It does confirm that Mr. Kelly, who was the, involved in that earth source matter, was in fact an officer and I think director of the company, and then does confirm as well that Mr. Christopher Carney was listed as a vice president of the company in that 2020 filing. I know the applicant, we had discussions over the weekend with counsel for the applicant, and I know they want to shed some further light on that, but that is what the document showed, and we did feel it was relevant, and so put it before you.
Thank you. Okay, commissioners, any questions for Director Lilios before we turn to Attorney Nozal and Attorney Maurizio? Okay. Then to the applicant and Attorney Nozal and Attorney Maurizio. Thank you so much.
Yeah, thanks, Chair, and thank you, Director Lilios, and we appreciate the explanation of how this document came about. And although certainly frustrating for something to pop up sort of in real time, we appreciate the opportunity to have had a chance to look at it. And honestly, at the end of the day, I'm glad we have an opportunity to address this issue and something that appears to show some discrepancy in what MGA has been representing prior to the commission going into any of its deliberations. So although the timing is tough, it's also right. And I want to put the document into some context for the commission. So as the document that's being referred to is known as a statement of change. And what this document represented for MGA was a proposed management structure in September of 2020 that was really never implemented. It was filed on September 14th, 2020, and then it was superseded when MGA filed its 2020 annual report and a further statement of change that was filed contemporaneously with that. And we've included some documents today that I'm going to refer to during our presentation, and I could just sort of walk through quickly. If commissioners want to refer to that packet, I'll go by the PDF page numbers for that. And I apologize, I think some of the slip covers for the documents might have gotten a little bit mixed up in the final production of that. So at page 2, I think you find in our PDF, the statement of change that was circulated on Friday. And then at page 5, you'll find the annual report that was filed in March of 2020, and that was for the fiscal year that ended in 2019. And then at page 8, you'll find the second statement of change that followed by the annual report, and that covers the fiscal year ending 11/30/2020, and that was filed again in April of 2021. The officers and directors in the September 14th, 2020 statement of change were on file with the Secretary of State's office for approximately 6 months. The September 14th, 2020 statement does list Christopher Carney for the first time as an officer of MGA. He wasn't paid in that position, didn't carry out duties in that position, and it was effectively eliminated when MGA filed its statement of change of supplemental information and the next annual report on April 12th, 2020. I do want to point out also, as Director Lilios indicated, that document contained other changes to the proposed management structure, including adding Bob Kelly, Letitia Carney, Mr. Carney's wife, and Maura Carney were also included as part of the same proposed management structure that was filed in September of 2020, wasn't implemented, and then superseded by the following supplemental information and annual report in 2021. As previously disclosed in our BED form, we had only listed Bob Kelly, Letitia Kelly, and Maura Carney as being directors through 2019. So I want to explain sort of how this happened. So we do need to update our BED forms, and we don't dispute that as a result of this document. In the due diligence leading up to the application materials, we missed the September 14th statement of change, and the leadership of MGA did not recall the change at the time the applications were filed. How did we miss this? The statement of change was not located at the time in the corporate records of MGM when we prepared the applications. And then when gathering the reports from the Secretary of State's office, we just looked at the annual reports, not any supplemental changes. And then because this change occurred after the 2019 annual report was filed, and then was later discarded by the time the 2020 annual report was filed in April 2021, we didn't include the information in the statement of change, supplemental information in the BED forms, and we should have. We have amended these forms, and we've included that those proposed amendments and how we would explain this in drafts of changes to Schedule 6 and 8 to the BED form filed by MGA. These are found at pages 15 and 16 of the PDF. We note the reasons why these changes were made in that document, and we update the correct dates for Bob Kelly and the other officers, and add Christopher Carney as a former officer as a result of the proposed management change that was filed with the Secretary of State's office. It wasn't intentional, wanton, or reckless, and it wasn't intended to mislead in any way. We certainly regret the error, and we shouldn't have stated to the commission that Christopher Carney was never an officer of MGA when, based on that filing, although it was just a preliminary and a proposed management structure, he was listed as an officer from September 14th, 2020 to April 13th of 2021. Again, it was proposed management plan that was never implemented and listed on the Secretary. It was listed on the Secretary of State's office for 6 months. And I'm happy to pause there and answer any additional questions that the commission may have regarding that and the updates that that will now require us to make in connection with the application.
Counselor, are you all set for questions from the commissioners?
I am. Yes, we are. Thank you.
Okay. Questions, and I understand that my microphone might be having an echo, or is it working other than the?
Little bit of an echo.
And so I'll take any guidance from Mills and Grace along the way if I can fix that. Okay. Any questions for Councilor Nozell? Commissioner O'Brien.
I do. So Attorney Nozell, I'm looking at attachment 6, the former directors, trustees document, which shows up on page 15 of my PDF. And it looks like 8 former officers, which is page 16 on my PDF.
Yep.
So I'm just trying to clarify where this is and where the markings, what they indicate. Is it that the typed submission in these attachments was up until you filed this, the BED submissions, and that the handwritten notations are the updates?
Yeah, so these are quickly done in draft form to illustrate to the commission the type of changes that are going to be needed to be made on the BED. So these are the original documents with both, and then with some handwritten notes as to how they need to be updated, including changing the dates of the directorships for the former directors and trustees for Mr. Kelly, Mrs. Carney, and Maura Carney. And then on the second, attachment 8, to then list, both update that again for former officers for Robert Kelly, and then add Christopher Carney in to that as a former officer as well. So this is meant to show here's what these changes are ultimately going to be look like. I mean, this is I guess I'll describe it, Commissioner. It's kind of a mock-up of what we expect to file. We haven't really had a chance to do that and get these filed with the IEB yet, but I wanted to let the commission know here's the way these changes are going to look ultimately when we make them. Probably in a little better form than the handwritten notes, but wanted to be transparent as to what this will change for purposes of the 2 attachments in the BED.
Okay. Yeah, I was just looking for a lot of times you'll see the sort of date that the change is made. So I didn't see that on here. So I just wanted to make sure that this wasn't done earlier, that this was done
No, this was literally done.
to basically effective today.
Yeah, it was, and I would say, Commissioner, not yet. Obviously, we
Right.
need this finalized and signed and sent into the commission. It was completed yesterday as an illustration of what we plan to do due to this mistake.
Thank you.
Any other questions? Okay, then I'll turn back to MGA. Attorney Nozel, I think you wish to respond to the supplemental report that IEB submitted with respect to preliminary suitability.
Thank you, Chair. Thank you, members of the commission. I do want to do that now. And just to kind of give you a quick overview of what I'm going to cover, I'm going to basically walk through MGA's application process and address some of the issues regarding disclosure that have been raised in connection with the supplemental report. And I think understanding the process from MGA's side will address some of these areas. Will address these areas of concerns. And again, those are found at page 29 and 32 of the IEB supplemental report. And I'm also going to address the business practices of MGA in the context of some of the things that we've done during the application process, including the removal of Chris Carney and the safeguards that'll exist going forward to ensure that these changes are met. I do not plan to address the suitability of Christopher Carney, except to the extent it impacts MGA's suitability. Again, it's our position that Christopher Carney should be removed from our application, and we request that the commission do that and then consider the suitability of MGA. So if I had to summarize the areas of concerns in the IEB report in connection with the suitability of MGA and its remaining qualifiers, it's really whether MGA's application materials were accurate and forthright, and are the business practices of MGA sound. Again, there are no findings in the supplemental report. These are just questions that have been raised, and we expect, I think, at the end of the day, that we'll be able to address all of these things through the full investigation into MGA suitability. But we did want to provide the commission with additional information in connection with the preliminary finding of suitability, as we've been discussing as well. So I'm going to talk a little bit about the timeline and the documents that were filed. And as the commission is aware, MGA submitted a copy of the scoping survey, or submitted its scoping survey to the commission, providing information on the business structure and ownership of MGA. The scoping survey, as we discussed previously, did identify Christopher Carney as the beneficiary of the Christopher Carney Trust because of the ownership of the stock. And again, we've given you a copy of that scoping survey, so you can see it. You can see the questions that were asked, and you can see how we answered them. And that's at page 17, starting at page 17 of the PDF. Christopher Carney's interest was included in the table of organization. Again, in connection with his beneficiary interest, according to the trust at page 19. In connection with control, which is found at page 20, the Christopher Carney Trust was listed as having control of 40% of the MGA stock. The directors and officers at the time were also listed. And then for prong 3, really as to who can control the applicant's sports wagering operations in mass, this was largely left as to be determined based on a potential third-party operator. So at the time of the application, Christopher Carney was not an officer, director, or shareholder of MGA, and he was not disclosed as part of the functional table of organization. We also did not list Mr. Carney in response to the control question. He didn't own 10% of the applicant. And at the time of the scoping survey, Mr. Carney was not an officer, director, or shareholder, and he wasn't an executive, employee, or agent having the power to exercise significant influence over the decisions concerning the applicant's sports wagering operations in mass. MGA did disclose his interest, and we believe that the scoping survey was accurate at the time that it was filed. And again, the same was done in connection with an update to that scoping survey that was filed on December 29th. And the purpose of that update was to identify, again, a change that we thought needed to be provided to the commission, in that we had created a new operating entity, the Raynham Park Sportsbook. The rest of the information, though, stayed the same as we went through and refiled that attachment. Obviously, on the scope, the licensing division ultimately issues a designation letter in January designating MGA, the George Carney Trust, the Christopher Carney Subchapter S Trust as entity qualifiers, and designating George Carney, Christopher Carney, and Joseph Capucci as individual qualifiers. And that's what you've had in front of you up to now. On January 17th and 18th, MGA and its qualifiers submitted its applications for a Category 2 sports wagering application, along with the requisite MJ PhDs, Mass Sup forms, and BEDs. It's important, and I think this has come out in some of our discussions, that MGA made 2 additional filings to the licensing division. In response to the licensing division's February 7th request for a list of proposed sports wagering vendors, MGA provided a spreadsheet listing its proposed vendors that does include C. Carney Environmental. This is at Exhibit 4 on page 26. And on page 29, the actual spreadsheet includes Christopher Carney's company as a construction vendor, as we've been stating in connection with his responsibilities in connection with the new building. And then again, in response to the licensing division's March 7th, 2023 request for occupational license information, MGA provided an updated proposed organizational chart that's been discussed. That was on March 16th of 2023. This chart listed Christopher Carney as the proposed COO of MGA for sports wagering occupational license purposes. This position was designated, and if you look at page 34 of the PDF, as new. The new organizational chart then follows it at page 36 of the PDF. It wasn't until after, as we've stated previously, that Chris Carney was designated a qualifier, that because he was a qualifier anyway, and that is noted again in that transmittal email, that he is a qualifier, that we then decided that he can also hold a managerial position with the proposed sports book. So in connection with MGA's application materials, it's also important to understand the business practices by which MGA's application and related applications were filed. MGA, as we have stated a few times now, is a family-owned business. It's been operating here for well over a half century. And despite this, MGA hasn't been required to go through a licensing process as a business qualifier. So it didn't have these forms on file. It hadn't completed them in the past. It was something that really had to start from scratch. Obviously, George Carney and other former executives, including Bob Kelly, had gone through the process in the past. So this process begins in late September through MGA's filing in January. We used outside resources to assist the preparation of the applications, including an outside accounting firm, outside regulatory counsel, and outside corporate counsel. With the input of the qualifiers, lawyers, and accountants, they put together the drafts of the documents. Additional research was done to compile litigation matters, needed business and tax records, corporate records, and financial information. Any previous submissions to the commission were also reviewed, specifically in relation to Mr. George Carney. Several drafts of the documents are produced and reviewed by the outside team. Drafts were prepared for each of the qualifiers and sat down and reviewed with each one individually. Questions that any of the qualifiers had were answered and ultimately signed by each one of the applicants. A representative MGA reviewed each of the applications in making the suitability certification. And as you know, and as pointed out in these reports, MGA certified that its qualifiers are suitable to the best of its reasonable knowledge. The supplemental report, and to a certain extent, the initial report by the IEB questions the certificate of suitability. I don't see that the supplemental report or the initial report suggests that MGA, George Carney, Joe Capucci have not answered questions accurately in the BED, MJ PhD, or Mass Sup, especially when it comes to anything pertaining to Patriot Recycling or EarthSource. Rather, it's really concentrating on whether or not the certificate of suitability was correct. As to the certification that was made on behalf of the MGA, I remind you, it was to the best of the reasonable knowledge and belief that the applicant and all the individuals and entities designated as qualifiers for application are suitable to hold a license pursuant to the the licensing requirements found in the statute and the regs. And of course, I'm paraphrasing. I think the forms certainly are well known by the commission. So in connection with the business practices of other companies, namely Patriot Recycling and EarthSource, MGA, as we have stated, does not own or control those businesses that were subject to the DEP enforcement actions. MGA did not know the compliance history of those companies, one of which was owned by Bob Kelly, who is not a qualifier, and the other by Chris Carney. And Bob Kelly was not otherwise involved in the application. And again, the fact that he is a former officer and director of MGA, as late as, based on the updates we provided 2 years earlier, regarding his separate business, these enforcement actions essentially had nothing to do with MGA. At the time of the application, MGA, in its reasonable knowledge and belief, was not aware of any issue that would make any of the qualifiers unsuitable. And we think as the IEB continues to investigate this matter, MGA is confident that its certification was made in good faith and based on its reasonable knowledge at the time, its understanding of the questions that were asked and the information that was required to be disclosed. In discussing the business practices of MGA further and moving along in the application process, I do want to spend a few minutes talking about the removal of Chris Carney from the steps that were taken from the MGA perspective. I want to cover the decisions to remove him as a qualifier and the business practices that support that. So as we stated, Christopher Carney was first identified as a qualifier due to his beneficial interest in the Christopher Carney Trust. At the time of the scoping survey, which I've covered, he was not an officer, director, or shareholder of MGA. He was a contractor, which was disclosed. After Christopher Carney was designated a qualifier, MGA proposed to make him the COO and include him in a file in the licensing division as a new position for scoping the occupational licenses. This again is reflected in the documents that we provided at page 34 of the PDF. The application process for MGA is then paused for the IEB to look into a particular additional matter. Then on April 20th, Christopher Carney makes additional disclosures to the IEB, including the 2023 ACO pertaining to the Galleria Mall and the civil lawsuit involving Prey Farm in Rehoboth. These things were both disclosed to the IEB by Mr. Carney through counsel. In addition, Mr. Carney then offered an opportunity to meet with the IEB on May 7th. After that interview, and with the knowledge that errors were made with Christopher Carney's application, and the IEB was focused intently on his recycling business practices, MGA made the decision to seek his removal as a qualifier, which we understood that the IEB had discretion to do. The request to remove was not novel. The IEB over years has removed many qualifiers. It has been an accepted practice to resolve a potential suitability issue with a qualifier in connection with an application or even a licensee, and one that allows the commission to meet two goals: protect the integrity of gaming and allow the business to continue on in the application process. And as we've stated, and as it documented in attachments to the IEB's report, MGA represented that at that time that Mr. Carney would no longer take on that role of COO, the new position that was created for him and disclosed in March. MGA did not propose at that time, however, to remove his beneficiary interest in the trust because we didn't believe that that alone required qualification. And we spent considerable time explaining the interaction, the trusts, and whether or not they met the statutory requirements for qualifications. We didn't want to make any further changes, certainly at that time, because it really affected the overall careful estate planning that had been done for the Carneys for purposes of holding the MGA stock. In late June, Mr. Carney was informed of some additional matters and made additional timely disclosures that ultimately allowed the IEB to finish its report. Upon receiving the report and reviewing the issues that the report concerned regarding Mr. Carney, MGA felt that these circumstances may raise challenges for the preliminary suitability of MGA. And that was basically the decision why we made the additional changes in order to eliminate any potential issues from a control perspective and other perspectives pertaining to his relationship to MGA. As the commission, as we've said many times, the preliminary suitability finding and a temporary license remains essential for MGA to execute its business plan, complete its construction of its new retail facility, and at that time was really important to keeping the arrangement with our operating partner intact. We had kept our operating partner obviously informed of these developments all along, including obviously providing copies of the IEB report. The decision to then remove Christopher Carney and divest the trust was also supported by our operating partner. For MGA, MGA has provided extensive documentation to the IEB regarding the transactions that resulted in the divestiture, which is very thoroughly summarized in the RSM third report. I just want to go through those quickly. MGA acted quickly to take the steps necessary to remove Christopher Carney's interest after the issuance of the IEB report. We didn't wait for the commissioner to require this divestiture. MGA sought outside trust and estate counsel to ensure the transaction met MGA's regulatory goals. Evaluation of the stock was performed. The transaction is documented in the corporate documents of MGA, the trust, and votes of each, of the trust and MGA. We also have provided all the additional information regarding an additional restriction in the demand note held by George Carney that's payable to the Christopher Carney Trust, and that we said that no revenue generated by the licensed sports betting can be used to repay that loan. RSM has raised no questions about that documentation. They have raised a question as to how MGA will keep the sports wagering revenue separate. We're happy to work with the commission in connection with MGA's internal controls to ensure that that will be the case going forward. MGA then went a step further. Although it felt comfortable that the existence of certain loans between Christopher Carney did not represent a relevant financial interest and the requisite influence or control required under the Sports Wagering Act for purposes of being a close associate, we took the safest course of action and eliminated these loans between Christopher Carney and MGA out of an abundance of caution. The allonge and assignment of those loans is also documented in the RSM third update. The steps that MGA took to remove Christopher Carney are illustrative of its understanding of the regulatory environment and the business practices that are required to operate successfully as a licensed sports entity. Continuing on with MGA's business practices, MGA, under the ownership and control of George Carney, has a long history of operating a wagering enterprise in Massachusetts, again, for well over a century, including under the jurisdiction of the commission. This has been done with integrity and honesty and cooperation with regulators. As it pertains to MGA, neither the IEB report nor its supplemental report raises any issues pertaining to MGA's simulcast wagering business or how the company has complied with various regulatory requirements over its years of operating and handling wagers. Dr. Lightbaum has reflected on working with MGA and its qualifiers and executives, including George Carney, Sue Rodriguez, and Joe Kikuchi, who are all here today, for almost, I believe, 30 years. We expect that MGA's prior history of business practices in racing and simulcast will be a big part of the durable suitability review. Putting aside the business practices of MGA and its history of compliance in the racing and simulcast business, the supplemental report raises issues regarding the business practices of two of MGA's approximately 30 tenants, Patriot Recycling and EarthSource, neither of which are part of MGA's business. MGA does not control the actions of its tenants, and MGA has not been accused of any wrongdoing as a result of its tenants' actions. No environmental enforcement action has been taken against MGA in regards to its property, against MGA for its property. Patriot Recycling and EarthSource are entirely independently owned, and MGA does not have any responsibility for the operations on or off MGA's property. This is not changed by the fact that Bob Kelly was an officer and director of MGA at the time of some of the DEP enforcement actions. I do just want to pause quickly. There's been a lot of talk about Bob Kelly. And I just want to, we should put his, I think him in context. He's somebody who's actually fairly well known to the commission. He's certainly somebody who's been, is very well educated as a Princeton and Harvard graduate. He's the former president of an engineering firm. And importantly, and I think this is important for certainly understanding, his past relationship to MGA. He has been a gaming qualifier. He's been found suitable by the commission previously and in 19 other jurisdictions in connection with his board position that he previously held with Gaming Partners International. So he's not somebody who just is associated with EarthSource. He has a very rich business and history in the gaming sector as well. So I also now want to move to the FEIR that was issued, and that's found at page 38 of your report. So despite not being responsible for creating the issue, certainly in connection with the biosolid, which the IEB report and the supplemental report spend considerable time, MGA has stepped in to mitigate the problem as part of the overall development of its land. As previously disclosed, MGA received its FEIR for the development of the Raynham Park land on August 17th. It's dated August 16th, and a copy of that again is in your packet at page 38. As part of obtaining the FEIR, MGA is committed to the removal of any remaining biosolid on its property. That's found at page 49 of the PDF, a process that's already begun and are conditions that were accepted by DEP. That can be found in connection with at page 54 and 55 in the DEP concurrence with the FEIR. The FEIR is by far the most comprehensive review of the property at Raynham Park and a document that historically and critically has been relied on the commission, by the commission, as a prerequisite to the development of gaming establishments. The FEIR, we would suggest, is the best evidence of MGA's business practices pertaining to its property based on a very comprehensive review that has occurred over time. I next want to turn back to what steps, not the steps that have been taken relative to Christopher Carney, but in connection with MGA's, from MGA's perspective, what is he still a qualifier for our application? And the answer to that question is no. We've taken steps to ensure that he's been removed from any proposed management role. Obviously, the trust has divested its stock, and having the recent loans for the construction of the sportsbook, the launch and the signed. As a matter of law, as Mr. Maurizio has gone over extensively, Christopher Carney has no control and will not have any control going forward, which I think is an important piece to this. And I'll talk about some of the safeguards in just a moment regarding the removal and how it will be actually effectuated. But we believe that this covers all of the definitional aspects of what anybody would be made, how anybody would be made a qualifier. In addition, including him not being a close associate, including him not being an affiliate, and as previously discussed by Attorney Maurizio, and in consideration of the changes that have been made, he does not have significant and substantial responsibility for MGA's business under the jurisdiction of the commission. There is a part of the report also that raises some questions regarding Mr. Carney, George Carney's MJ PhD, and I wish to turn to those again so the commission understands how we are answering questions that are put before it. So the IEB supplemental report questions the accuracy of George Carney's MJ PhD, specifically whether or not he should have disclosed Christopher Carney as part of his answer to question 27. We interpreted this question to require disclosure of any family member that has a current legal relationship or is an employee of the gaming business. And we did provide you a copy of that particular question it's at the last page of the PDF if you want to refer to it. So George Carney did not list Christopher Carney in his answer. As we have stated many times, Christopher Carney was not an officer, director, or shareholder, or employee of MGA at the time of the application. He was listed as an officer, as we disclosed, as determined by the information that was provided by the IEB on Friday for 6 months from September 2020 to April of 21. As we previously discussed, he was considered for a prospective officer position of MGA that was never consummated, and that was after Mr. Carney's application was filed. We did not interpret Christopher Carney's work as a vendor for MGA on the construction of a building that did not involve any licensed gaming activity or his beneficial interest in the trust responsive to the question either. Mr. Carney answered the question with the advice of his advisors. In no way did he make a false statement of material fact, certainly nothing that was willful, knowing, or reckless, or intentional. MGA is confident that the IEB's full investigation will confirm this fact. We do have another matter, though, to discuss in connection with Mr. Carney's answer to question 27. And we've informed the IEP of this, and we want to make sure that we're being 100% obviously transparent to the commission as we learn information that needs to be updated. We understand that this question does need to be updated for separate and distinct reasons. In completing the question, we did not include employees of Taunton Dog Track in connection with that answer, which Taunton Dog Track, by way of background, is licensed also by the legislature to conduct simulcasting, and therefore would likely meet the definition of a company involved in gaming under this question. Robert Kelly and Maura Kelly are on the payroll of Taunton Dog Track and should be listed in response to question 27 on the MJPHD. The records of Taunton Dog Track were more carefully reviewed over the weekend, and we wanted to make sure that this error was known to the IEB and to the commission, certainly before going into any discussions about the overall suitability of Mr. Carney or MGA. And we will update the question accordingly. Again, this was an error. We're self-reporting it, and we're going to correct it. Nothing was intentionally withheld, but rather through further due diligence, we learned of additional information that needs to be included in the MJPHD. This is separate and distinct of our position that nothing needed to be disclosed regarding Christopher Carney in connection with that question, which again, we feel is going to be found ultimately by the IEB is going to be the case. An important aspect of what the commission is considering, and I believe it was really Commissioner Skinner who sort of pointed this out, was, okay, we're arguing a lot about sort of things that have happened in the past with MGA, but what about the future? What are sort of those guide rails for our future compliance, especially when it comes to Christopher Carney? And I want to walk through those because I think, again, it's an important consideration for the commission, and it goes directly to the heart of MGA's current business practices. First, as I've discussed, and I won't go over again, the divestiture and allonge and assignment of the loans is complete. Christopher Carney's management position has been eliminated, and the limits placed on Christopher Carney's involvement with MGA will be overseen in the first instance by MGA, and it will be our responsibility, and then it'll be enforced by the commission. And of course, as we've indicated, and we certainly expect that these things can be conditions to ultimately its license or restrictions on its preliminary finding of suitability to reflect these changes. Specifically, that Christopher Carney will not be a director, officer, or employee, or hold any position with MGA or its affiliates until Christopher Carney meets applicable commission licensing requirements. MGA will not enter into any arrangements that would make Christopher Carney a close associate or affiliate without commission approval. And MGA will not have any arrangement with Christopher Carney that will give him significant and substantial responsibility for MGA's business under the jurisdiction of the Commission of Sports Wagering and of sports wagering operations in Massachusetts. Memorializing these as license conditions or restrictions on MGA's preliminary suitability determination will provide the commission with the corresponding authority to take action quickly and immediately if, in fact, these conditions aren't met. In addition to the commission's enforcement authority, MGA has put in place enhanced corporate governance to ensure that it can meet the commission's internal control requirements, including, as I mentioned, a new governance committee and an audit committee. The governance committee is comprised of 3 members, including an independent member, and is responsible for ensuring MGA, its subsidiaries, and service providers are in compliance with all laws and rules and regulations of the commission. The audit committee will be comprised of all independent members, and in addition to overseeing financial audit and reporting, will also audit compliance. Finally, the likelihood of any unlicensed individual or entity having influence or control over sports wagering at the Raynham Park Sportsbook is further diminished through the fact that we hope to utilize Caesars for this, but to have a third-party operator of the sportsbook. This will provide additional compliance safeguards in addition to the operators, in addition to the licensee's own compliance and audit functions. So hopefully we can revive our operator agreement, but in any event, that still remains our plan. And we anticipate that any operator would end up being a qualifier, such as Caesars was designated. So the bottom line is there'll be significant safeguards in place to ensure that only those who are licensed by the commission will be involved in the operation and oversight of the sportsbook. And failure to do so will absolutely jeopardize this company's license going forward. So in conclusion, we of course first request that the commission grant the request to remove the Christopher L. Carney Trust and Christopher Carney as part of its application. We think then, in review of the overall suitability subsequently of MGA and its remaining qualifiers, we do have demonstrated the integrity, honesty, and good character to be issued a sports wagering license. As demonstrated today, our suitability certificates were made in good faith, and all other questions and forms were answered honestly. And where we've made mistakes, we've come back and said we've made mistakes. MGA has no pending litigation, and the open source research done by the IEB in connection with its initial preliminary suitability report contained no derogatory information about MGA, George Carney, or Joe Kikuchi. The RSM report identifies some risk in Raynham Park's finances, especially around the final financing of the new sports book, which would be great to have, but we can also move forward without that building, as we've suggested earlier, in connection with a temporary space located in an existing facility. However, recent developments regarding its real estate likely places MGA in a stronger position than when it first applied, including the issues last week of the FEIR for the development of the Raynham Park land. MGA has extensive experience in wagering in Massachusetts, something that the legislature recognized in setting aside a sports wagering license for MGA. This wagering experience, as recognized by the legislature, provides the business ability to establish and maintain a successful sports wagering operation. Although its current lease agreement with Caesars is terminated, there is a high likelihood that a new agreement can be entered into if we can get through these first two issues, including the removal of Chris Carney and a preliminary determination of suitability. After the removal, we believe we do meet the requirements for preliminary licensure as applied to all the other sports wagering licensees. MGA requests that it be found preliminarily suitable under the same standards applied to the other sports wagering licensees. Again, as we discussed earlier, for the limited purposes of 205 CMR 215 and conditioned on a finding that MGA adhere to the representations pertaining to the removal of Christopher Carney and that MGA revive or replace its operating agreement. I appreciate the opportunity to provide some additional context and respond to some of the issues that are raised in connection with the IEB supplemental report, and we're happy to answer any questions, including those around the additional disclosure pertaining to George Carney. Thank you.
Questions for Attorney Nozzle, and thank you, Attorney Nozzle. Okay, I see Commissioner O'Brien.
Attorney Nozzle, so can you identify who the new COO is in that list of officers?
We've just eliminated that position, Commissioner O'Brien. So there's no COO, and we did provide an updated, I believe, org chart to the IEB, and I thought that was attached to an exhibit in the original IEB report. I'll see if I can find it, but
okay, yeah. If you have a page number or something, exhibit number, if you could let me know, that would be great.
Loretta, Director Lilios, I'm not sure if you recall, I think it was attached to one of our letters. Sorry, I do have it, Commissioner. It's in the original IEB report, exhibit number 15. And it's exhibit B that was attached to that, which includes this was in removing the COO position, our proposed structure for MGA going forward.
Thank you.
Yep.
Commissioners, other questions? Commissioner Skinner.
Thank you, Chair. Attorney Nozzle, my question pertains to the Taunton Dog Track. Could you just describe the relationship between MGA and that entity?
Sure, I may defer to others that have kind of the best knowledge of that. Let me just confer to see who's the best to answer that question, if I can just have a moment. Due to his long relationship with MGA, Mr. Maurizio is going to answer that question.
Good morning, Commissioner Skinner. The Taunton Dog Track operates the simulcast business for roughly 6 months of the year. And MGA operates the simulcast business for the other 6 months of the year. They don't operate together. That's been the practice since as far back as I can recall. It comes about during the days when live racing wasn't 12 months of the year, that there were very specific race dates that each racing licensee obtained. And so Taunton Dog Track applied for from the old Racing Commission its own set of race dates. MGA applied for an entirely different set of race dates, and the old Racing Commission granted those dates. At some point, the legislature changed the law to allow essentially year-round racing, and but those two companies then operated independently during their own set period of time, roughly 6 months each.
And so are the two entities also independently controlled?
Oh, yes. The only commonality is that they're under the control of George Carney as the chief executive officer or president. But they themselves do not exercise control over each other. They're independent companies.
George Carney is CEO of both.
Essentially CEO, president.
And
So,
I'm sorry, go ahead, Attorney Nozzle.
No, I was just going to say, we did disclose all of this actually in the scoping survey as well. And that's, I think I previously referred, it's on the third page of the scoping survey.
Okay, thank you for pointing that out, and you'll have to forgive me. I am on vacation and we got these documents very late last night, so I haven't had an opportunity to read every single one of the documents. So I will defer my remaining questions on that subject until I've had an opportunity to review that scoping survey, just in the interest of time.
Commissioner Skinner, would it be helpful for us to point to the exact page because it might be straightforward? What
Nope.
page was? No, okay.
Yeah,
I
have the document open. I can find it.
Okay, I just was wondering.
Thank you, though. I just, in the interest of time, I'll move on if the information is clearly laid out in that document. Relative to the board of directors for MGA, I think right now, according to the documentation, George Carney is listed as president, secretary, and treasurer. Is there any plan, or is there a plan to change that, or will that be the case going forward?
I can't really speak to, I guess, future plans. I can say that that's how the company sits today. That's how we expect it to be evaluated by the commission. And I don't have any additional information on any planned changes for that. I think obviously if that were the case, that could have implications for, not only updated Secretary of State filings, but and we understand that could have obviously regulatory implications as well. And if we did make any changes, we'd go through the standard process that I think, Commissioner Skinner, you probably understand just as well as anybody from the licensing division. We'd notice the division, we'd go through a process of identifying whether or not that person needed to be a qualifier. If they did, fill out the paperwork within the designated amount of time, and then go through that process if we did make any changes.
Understood. Are you able to provide any additional information as to who will comprise both the governance committee and the audit committee, and what that reporting structure will be to the board of directors?
CPAs.
Yeah, so I'm going to let Dan O'Brien has been leading how we are going to populate that. We can talk a little bit about the process that we've engaged in order to identify those individuals. I don't think we can name individuals by name at this point, but Dan, why don't you talk a little bit about the process?
Yes, we hired a consultant to come up with a list of qualified candidates for the audit committee and compliance committee. And we interviewed a series of people. Most of them were CPAs with practice in publicly held companies. Some of them have gaming experience. So we have a list of candidates who are all CPAs that we've identified for the audit committee, who are able and willing to take that position once we can go forward on it.
That's for both committees.
So the compliance committee will have one independent member that, Dan, I believe we've also asked for applications for from.
Yes. Yeah, so it'll probably be a CPA will be the independent member of the compliance committee.
And that's just one member, did you say?
Yes.
And three individuals governing the on the governance committee.
On the compliance committee, yeah. So there'll be two others named by MGA. Right now, our plan is to name folks internally for that committee.
The other part of my question, I don't think got answered. What's the reporting structure of each of these committees to the board of directors?
It's I think that's covered. I don't want to misspeak. It's covered and in compliance with the internal control regulations, which are very particular, and I believe they have to report both to the board, and I believe that's the case.
I believe they would report quarterly or as needed as any issues came up.
Could you repeat that? I'm sorry.
I believe that they would report quarterly after each meeting, and then as needed if any issues came up in the interim period of time.
Well, the nature of my question is more towards checks and balances, if you will. I mean, you have one individual who is serving in essentially makes up the entirety of the board. And you have governance committee and audit and compliance committee, where, you know, they're all reporting to one individual who is essentially what's being represented today.
Yeah, I just want to be.
MGA. I'm just wondering
Commissioner, I
what
want to be clear that the
1
board-
minute, please. I think Attorney Nozel was going to respond to your last statement.
Yeah, I
go
just
ahead.
wanted to be clear. The board of directors of MGA is both Joe Capucci and George Carney. So there are two individual board members at this time.
Yep, okay. My apologies, I did catch that. Joe Capucci is the
CFO.
CFO, right?
Yep.
What's the relationship if there's any familial relationship between Joe Capucci and George Carney?
None. There's none. There's no familial relationship, just a long work history.
Okay, thank you. But I think you understand, Attorney Nozel, what I'm getting at. You were nodding as I was trying to frame my question. You have George Carney, who is the figure on behalf of MGA. I'm really, and I don't think I got an answer. I'm really trying to understand the relationship between George Carney as president, owner, CEO of MGA, and each of the members who I understand have yet to be identified formally of these committees. Can you speak to what that, you know, how we talk about assurances, you know, that, so the question pertained to assurances that Mr. Chris Carney will no longer be involved in the day-to-day operations of MGA, and where you have ultimately Mr. Chris Carney's father, George Carney, responsible for ensuring that that happens. I still need some assistance in understanding what exactly are the assurances. I mean, I understand the proposal to create these committees, but talk to me about how they will work to ensure that, they are keeping the commission's concerns relative to Mr. Chris Carney's involvement at the forefront, and that they are empowered to address any compliance issues
Sure.
relative to that.
So
Attorney
those,
Lozo.
we really don't have a lot of discretion there, Commissioner Skinner. The commission's regulations, specifically its internal control regulations, are very prescriptive as to how these committees need to operate and function. And they're set up very deliberately. So I can say, if we want to have, if you have putting aside sort of the composition of the current board of directors of MGA, I can say that the compliance committee and the audit committee will be set up in a manner that's equivalent to what you've required for every other, not only sports wagering company, but also the gaming establishments as well. So they'll have to meet those requirements. And if you look at those regulations, they're actually pretty prescriptive in what those committees have to do and the membership of those committees. So we have to meet those minimum standards now. And that's why we designed these two committees, not to be put in place in order to deal with this particular issue, but this is about the overall operations of MGA. And what we're doing, and it'll be, is really taking what has been run as a family business for a number of years and adding in the new regulatory obligations that we have. So we would need to meet the internal control regulations, which require us to have a compliance committee that includes an independent member, as well as then an audit committee. And what that is designed to do is ensure that those two committees have outside voices, the compliance committee at least one, and with the audit committee at least three, regarding the overall operations of the sports wagering book at Raynham Park. So, from my perspective, the company is putting in place the processes that will provide the commission with the documentation, ultimately through the compliance committee, of if and when or how it's meeting these obligations. And then obviously the audit committee comes in and make sure that that actually has happened as intended. So again, I'm reverting back to the structure that the commission has accepted for purposes of overseeing not only sports wagering operations, but also the gaming establishments as well. We're going to populate those committees certainly as required under the regulations. And this is on top of the fact that as now a regulated sports wagering entity will also be subject to several other rules under the commission, right? Your ability to show up demand records, your ability to come in and audit anytime, our requirements to do reporting on these things, our requirements to produce now not only audited financials, but annual audits as well. So I think the structure is going to be in place that will essentially give the commission visibility into just about everything that MGA is doing when it comes to compliance with its license conditions, the law, and the regulations under the commission's jurisdiction.
Thank you.
Sure.
I don't have any other questions at this point.
Madam
Commissioner
Chair.
Hill.
Thank you, Madam Chair. So I think we talked about this on Friday pretty much at length, but I still need some more clarification when it comes to the financial stability of what we're dealing with here. And I'm a little concerned because if I'm looking at this the way through the lens that I think I need to, I have to look at the facts that are before me today. What is not before me today is now an operator because Caesars has pulled out. So a red flag needs to go up because now I'm trying to understand financially how we're going to make this work. Can you comment on one? I know you touched upon this about Caesars on Friday, but I also need to understand how we're going to make this work even when you do have an operator put into place. And I think that may be an executive session question, because I think that, it may deal with, competitively sensitive information. But these are two issues that I've been really thinking about that I really don't understand today because of what's in front of me today.
Sure. I think you're right, Commissioner Hill, that in order to respond here, we may need to go back to executive session, and we may need RSM involved in this discussion as well. But I just want to stress conceptually what we are asking for. We're not asking you to unconditionally find the applicant in particular in connection with its ability to operate a sports wagering business as contemplated in connection with the regulations, just outright. We are asking you to conditionally find that MGA has the first part of that based on its experience in as a simulcast operator, and then only if we can come back with an operator that we would be found financially suitable for purposes of the overall application. So we do recognize that the operating agreement provides a gap, right? And we're saying we can and expect to put that back together, and we don't want the commission to do anything more but give us this conditional approval, which it can do based on that actually occurring. So if it never occurred, Commissioner Hill, if we couldn't come back to you with an operating agreement, we'd be done. We would never be able to meet that suitability requirement. So we expect that is a necessity, I think, as you do. And we expect that we would only be able to move forward, in fact, if we got that piece put back in place.
Commissioner Hill, follow up?
Not necessarily a follow-up, but maybe a new line of a new subject matters. I'm trying to also understand that if we were to remove Christopher Carney, some of the financial pieces of the puzzle that were put into place have now been removed, if I understand it correctly. And I want to be clear on how we move forward with loans and things of that sort to ensure that this is financially stable moving forward.
Again, I want to offer the opportunity for an executive session. I believe that I think this may have come up in the public discussion on Friday, but I'm not positive. So I turn to you, Attorney Nozel.
Yeah, Commissioner Hill, if I understand your question, we don't see the removal of Chris Carney affecting the balance sheet of MGA and what's been presented. It certainly affects Chris Carney's potential, it affects the trust's balance sheet. It affects George Carney's balance sheet, but there is a distinction between what we've presented essentially as the business plan for MGA going forward, again, with an operator agreement. And I'm happy if we need to get into the details about this to discuss those, further, but we'd have to probably get into some personal financial information, which I think we need executive session for.
I believe RSM also has weighed in on that issue, Commissioner Hill, so it'd be right for the executive session. And then always, if we determine that belongs in the public sphere, we'll turn back to the public forum.
Well, then at this moment, Madam Chair, that's all I have for now. Thank you.
Okay, and so we'll just right now put in the parking lot the issues around the finances that you just raised and the need for executive session. See if we should do that before further discussion, but I want to turn to Commissioner Maynard.
Thank you, Madam Chair. Attorney Nozel, I appreciate you discussing the future relationship with Mr. Christopher Carney. I think that's, to me, the most important piece of this. You stated that Mr. Christopher Carney would not engage with, and you can correct me if I got my notes wrong, any gaming related business with MGA, and my ears perked up when I heard that. Understanding the commission's authority, including reaching into vendor relationships, even having the authority to grant waivers. How broadly are you defining gaming related business?
Commissioner Maynard, it would be anything that's under the jurisdiction of the commission that we would need to come to the commission for approval in order to engage in. So, there's not an issue regarding whether or not Christopher Carney can or can't be a vendor at this juncture. We'd have to cross that, I guess, bridge when we get there. We are identifying the fact that he has been a vendor, certainly for MGA. So, again, I think that question is really related on what, if any, relationship or that the MGA intends to have with Christopher Carney going forward. And I've indicated the ones that we absolutely are not going to indicate in. And if there's anything else out there that requires commission approval, we're going to be, coming to the commission essentially to review that. So what we're telling you right now as to what we're proposing certainly is, no management role, obviously, no financial interest. And whether any of that ever changes in the future, we would come back to the commission for purposes of, any appropriate application or approval that would be necessary.
Thank you, Counselor. And you really hit to the heart of my question, which was you're going to involve the Gaming Commission anytime this could even potentially come up.
Yeah, Commissioner, I think it's a point. Certainly we're in the application process for licensure, and we're working to meet those expectations. We fully understand that the relationship between MGA and the Gaming Commission has changed dramatically because of this application, and upon licensure will change dramatically again, and will require many more touch points, involvement, intimate involvement by the commission in MGA's business going forward.
Thank you. That's all.
Commissioner Skinner?
Thank you, Madam Chair. Would it be appropriate at this juncture to hear from IEB relative to Mr. George Carney's disclosure with respect to Robert Kelly and Maura Kelly, and specifically whether or not it poses any concerns around preliminary suitability?
Hi, Commissioner Skinner. And just a point of clarification, I think it's Robert Kelly, and is it Maura Carney, Attorney Nozel? Is that
that's correct, Maura Carney.
Okay. Maura Carney, okay, which I believe is Mr. George Carney's daughter, if I have that right. So, so thanks for the opportunity, Commissioner Skinner. We're in this preliminary review stage where the IEB's role is really to be of assistance to the commission in gathering facts and summarizing the application. And in this case, we did go beyond the application and gather those facts for you. But I'm very cognizant of our role in this preliminary stage, which is not to offer an opinion or a recommendation, but to help you with your fact gathering and help you with your evaluation of the facts. I do think, though, that disclosure is relevant to you. At the hearing on Friday, it was represented that Mr. George Carney is the currently the general manager of the property, and so the omission of the two family members on question 27 in his personal disclosure form may be helpful to you in evaluating the overall fulsomeness of the disclosures, as well as how you can evaluate these assurances that are being made about what to expect in the future. And I think they're relevant as well to your evaluation of overall business practices. I do, however, appreciate the disclosures that were made, and I know the page will be updated accordingly.
Mr. Attorney Nozel, do you want to respond or?
No, we're making we're self-reporting this, and it wasn't done in any way intentionally. And as to, Maura Kelly and Bob Kelly's, Maura Carney's involvement, I don't think in connection certainly with the simulcast piece, or Bob Kelly were certainly identified by, Dr. Blightbaum as, being involved in that business. Again, they're on the payroll of Taunton Dog Track. They aren't officers or directors. We're making this disclosure. Didn't want this as soon as we discovered it. Obviously, the timing certainly isn't ideal in connection with the process that's going on now, but we want to make sure that the commission knows what we know, and that we do feel that we need to update that particular form for George Carney. But again, it was based on additional due diligence that was completed, really over the weekend. We've disclosed it as soon as we identified the error, and we appreciate that the commission would take that into consideration in connection with the preliminary finding of suitability.
Attorney Nozel, I did have the opportunity to review the scoping survey, and one answer I cannot find here in the documentation after quickly skimming is George Carney the owner of the Taunton Dog Track?
Yes, and I believe that would probably be in the BED, Commissioner Skinner. I don't have a reference to it at this point.
Other questions, commissioners? I'm going to turn now to you, Attorney Grossman. We are looking now to turning to decision-making process. Commissioner Hill has asked about a finance question. I believe it may be in the context of the preliminary suitability, but perhaps we would want to hear from that before we turn to the request for withdrawal. Does it make that sense to go into executive session to clarify that rather than turning to what I understood from your early guidance last Friday was to turn to the decision of the withdrawals first?
Yeah, thank you. I think you're absolutely right. I think those questions do go to preliminary suitability, as financial stability is a component of that. That said, we have taken the position throughout these proceedings that all of the facts, and I think that's true here, are relevant to both considerations. So I think unless there's any objection, it makes sense to try to establish all of the facts first before moving into decision making. So if the commission is so inclined, I would suggest we address the questions that Commissioner Hill has inquired about in executive session, if the commission again is so inclined. The first goes to the present and future financial projections of relative to the operator's financial status. And the second relates to the status and terms potentially of the loans between Chris Carney and MGA. I think in both cases, they implicate competitively sensitive information. That all of this has been provided in the course of this application for an operator license, and could certainly place the applicant at a competitive disadvantage if these things were spoken of publicly. Similarly, I think there is a case to be made that there are privacy concerns as they pertain to Mr. Carney himself, if we were to get into the terms of the loans that are outstanding. So for both of those reasons, again, if the commission is so inclined, I think the commission can move into executive session to discuss both of those issues. And I think I would do it now rather than later.
Thank you. Thanks for that guidance. Commissioners, are we nodding our head in agreement? That seems best. Okay, then, per the open meeting law, the commission anticipates that it may meet an executive session in conjunction with its review of the application in accordance with GL Chapter 30A, Section 21A7, and GL Chapter 23N, Section 6I, to consider information submitted by the applicant in the course of its application for an operator license that is a trade secret, competitively sensitive, or proprietary, in which, if disclosed publicly, would place the applicant at a competitive disadvantage. And, or GL Chapter 4, Section 726, subsection C, the privacy exemption, to consider information submitted in the application materials related to named individuals, the disclosure of which may constitute an unwarranted invasion of personal privacy. Commissioners, do I have a motion?
Madam Chair, I move that the commission go into executive session on the matters and for the reasons just specified by the chair.
Second.
Thank you. Any questions? Okay, Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Maynard.
Aye.
And I vote yes, so 5-0. We'll go into executive session, but we do anticipate coming back to the public session. I will have a screensaver go up. Thank you to our communications team, and we'll be transported to our new session. Thank you. Dan.
So no worries. So I have opened a breakout room and invited those who I have on my list. If there are those who need to be included who have not been added in there, please feel free to let me know. I'm going to be going through and adding some additional ones as well. Mike, you're going in there as well, right? You're muted currently.
Yes, me, Dave, and Kevin Murphy, please.
All set, just added you guys.
Thank you.
Okay, I think we can turn down, take off the screen, please.
All set.
Thanks, Dave. I think we're all here. This is a reconvening of the Massachusetts Gaming Commission, and we started the morning off at 9 a.m. We are just returning from an executive session. Thank you to the public. We'll do our roll call because we are holding this meeting virtually. Commissioner O'Brien.
I am here.
Commissioner Hill, good morning again.
Good morning, I'm here.
Commissioner Skinner, good morning again.
Good morning.
And Commissioner Maynard.
Good morning.
Okay, and I'll turn back to Councilor Grossman. We went into executive session with respect to kind of looking at the current and future financial stability questions that we might have, relying on RSM, and then also some lending arrangements. And now I'm wondering if we are in a position to turn to, I guess it's item 4 on our agenda, in our decision-making process, 5, I'm sorry, our discussion on decision, or should we do a check-in with the commissioners first? Make sure everything's all set.
I think that makes sense, just to make sure that the evidence is essentially complete. There's no more information that any of the commissioners would like to hear. No more points that either MGA or the IEB has to make, and then the commission can move into the decision-making process.
And again, I think that we just have to remember that we use the word evidence, and that sounds a lot more formal than, because it really is not an adjudicatory hearing, but it is all the information that we are collecting with respect to the lens that we're looking, the more narrow lens that we're looking at the application process, right?
That's fair. Yes, the evidence meaning just information before you that you'll consider in making a decision.
And so if we had a question or we wanted more information, we can turn back to both IEB and MGA.
Certainly.
Okay, good. Just a reminder, commissioners, do you have any other questions then for the MGA or for IEB? Are you ready to turn to item number 5? Commissioner O'Brien?
So Madam Chair, I'm sorry, I don't have the agenda from Friday up. 5 is what, the motion to de-designate?
Discussion and decision regarding request to withdraw and preliminary suitability.
Okay, sure. So my position on the motion to withdraw or de-designate, however it wants to be captured, which to me, I'm separating out somewhat from the question of suitability.
Can I just pause because I was checking to make sure every commissioner was ready to go to.
Oh, sure.
Sorry. Commissioners Hill, Commissioner Skinner.
I am ready to move into the discussion. I just a procedural question, Chair. Relative to some of the other components of the application, for instance, Section D related to diversity, will we be following the procedure the way we have been doing it in the past with other applications when it comes to preliminary suitability? Because I think we still need to hear a presentation from the applicants relative to Section D.
Well, we do have other parts of the application, but it's my understanding we were just looking at preliminary suitability, and that's I forget which section of the application it is, just that narrow discussion. And then we would have to, because in fact, I think we've talked about the fact the application has changed in nature generally, we would have to go back depending on circumstances, and absolutely diversity is one that's outstanding. They have, it was, if I recall, we took our temperature on it, Commissioner Skinner, and then there was requests and they have filed. But today it's not marked up for us to go back to the application. If it's that fair, I'm going to turn to Councilor Grossman.
Absolutely, and let me try to be as clear as possible to that point. If the commission grants all of the requests that are before you as presented by the applicants, they would not be entitled to move forward towards a temporary license at this juncture. That's not the question being presented. This is a very narrow subset of that. And there's two questions. There's the withdrawal question, which I've recommended you take up first, and I think you were prepared to do that. And the second question is just one of preliminary suitability under section 215 of the commission's regulations, not 218. And 218, you'll recall, is the provision of the regulations under which you evaluate the application holistically to determine whether you will allow the applicant to move forward in the process and ultimately begin operations. So that's for a different day. Right now, you're just looking at whether you're going to allow the two entities and an individual to withdraw as qualifiers and whether you find preliminary suitability. But even with that preliminary suitability finding, the applicant cannot commence operation, to be clear. And we can talk a little bit more. We've mentioned them before and we've gone through them, but now that you're in the decision-making stage, we can certainly go through the governing provisions of the regulations and law as appropriate and as helpful now or as you begin the discussion.
Right, so I was going to turn to, I know that Commissioner O'Brien was ready to go, but I do think we have to have that reminder of the regulatory framework and any particular statutory provisions as well. And this would be, at this point, we can bifurcate and focus on the request for withdrawal, correct?
If the commission is comfortable with that, I think that is a good place to start.
Does that make sense, commissioners? Remind us of which provisions? Okay, thanks.
Sure, and I might turn momentarily to Ms. Monahan to jump into the particulars. I'll try to tee it up at a higher level for you to help calibrate the thinking now that you've heard all of the information pertinent to that and offered the applicant an opportunity to present its side. So you'll recall that the withdrawals are governed by section 213 of the regulations. And essentially they require good cause in order to allow an entity or an individual to withdraw at this juncture, since you have already commenced reviewing the application. And I think the easiest way to look at it is that there's two pieces to that. There's, in determining good cause, you have to look at whether the individual and the entity are required to be qualifiers, and Ms. Monahan will go through that momentarily. And if they're not, the question is whether there's any of the discretionary language that you would look to and feel as though certain the entity or individual should be a qualifier, even if they're not required to be that. And in making those decisions, there are a couple of things that you'll want to look at. Essentially, whether either Mr. Carney or the trust are considered to be a close associate of the applicant. And that's discussed under section 6 of chapter 23K. And we'll get into that in a little bit more granularity. And then the second ultimate question is whether there's a business association of any kind. And that's discussed in the regulations under 215.02 paragraph 2. And if neither of those are in place with whatever conditions might be appropriate, you may elect to allow Mr. Carney and the trust to withdraw and no longer be qualifiers. When you're looking at the close associate piece, you're looking at a couple of different things. And again, we'll go through the specifics, but you're looking at the financial ties. Have they truly been severed? Is there any relevant financial interest in things like the outstanding loans, the promissory note, the financing of the project? And all of those things are related to whether there are financial ties still in place. You also have to look at things like whether Mr. Carney in particular would be a director or officer of the entity. Those go to whether he is a close associate, and that's actually a statutory and regulatory provision as to whether he is or he is not a director or officer of the organization. Ultimately, you're looking still at whether there's a beneficial interest, whether either the entity or the individual have a beneficial interest in the applicant. And you want to kind of go through the list to satisfy yourselves that you know the answers to all of those questions. And if you satisfy yourself that there is no relevant financial interest and he is not entitled to exercise power over the operations of the entity, then you may find that he is not a close associate. And that may require some conditions to be put in place too. One of those things to look at when you're looking at whether he's entitled to exercise power in the operations is what the nature of the communications between Christopher Carney and the applicant is or will be in the future. And there is precedent for looking at that as well. And we've talked a little bit about that in the past. So I think those are the fundamental considerations that go into whether someone is or is not a close associate. And the second part is the business association, and that is a little bit more discretionary. The commission has opined on that. That is not a defined term, and I want to make sure I get this right before I move forward here. Hold on one moment. Yeah, so the term business association is not a defined term. The commission has addressed that issue in a slightly different context under Chapter 23K when it reviewed the question as to whether Steve Wynn was still a qualifier to the Wynn Resorts application. It discussed how it went about determining whether there was or was not a business association, and that might be relevant at least to know about and to think about in this context as well. So those are the issues that are directly before you for making this decision. And again, we're looking at just whether Mr. Carney and the trust should be allowed to withdraw. We're not looking at preliminary suitability at this moment. We're just looking at that very narrow issue. So with that, if it would be helpful, I might ask Ms. Monahan to jump in and to walk through the actual regulations and statutes that govern the principles that I just mentioned.
So I'm happy to do this one of two ways. I could read through all the statutory and regulatory factors regarding qualification first, so you have them in your head, or we could just go through them one by one and the commission could decide, yes, this applies, no, this doesn't apply, whatnot. The second way might be a little bit cleaner.
I guess I think for me, and I would want my fellow commissioners to jump in, we have been presented with a request and it was written in a document by Mr. Nozzle with a couple of related documents from Mr. Maurizio. And I guess the way that I need to think about this is they have to show good cause, right? So if we just start going through everything all at once, it's going to be a lot. I think all the commissioners have materials in front of them. If they don't have the reg in front of them, I think we got to give them a chance to get in front of them. Or they have to show good cause, and I guess we have to show that they haven't demonstrated that they must be required. So I think how Todd framed it, it might make sense to start us there, Caitlin, commissioners.
Right.
Yeah, I actually had a slightly different understanding of what was just said by Commissioner Grossman, so I'm curious to hear what Attorney Monahan has to say.
Okay,
So-
I'm
so
not
sorry.
saying she shouldn't say, but I just wonder if we want to have everything read all at one time or.
So let me just set this out a little bit more clearly. So as Todd explained, the commission the commission does need to determine whether or not there is good cause to grant the requests for withdrawal. However, in order to determine if there is good cause, there's a gating factor, and that is whether either Mr. Carney or the Carney Trust are mandatory qualifiers, or whether the commission believes in its discretion that they should be a qualifier. In the event that they are mandatory or discretionary qualifiers, that sort of ends the good cause discussion, because there can't be good cause if they're still a qualifier for them to withdraw. If the commission
Go ahead.
if the commission determines that Mr. Carney and or the trust are not qualifiers or are not mandatory or discretionary qualifiers, then it can determine based on that whether there's good cause for the withdrawal. And again, that the whether or not there is good cause is very discretionary on the part of the commission. So what I was suggesting, just for process, is to start by thinking about Mr. Carney's request for withdrawal, and then to walk through the mandatory factors.
Yes.
So, factor one, just as an example, a person who owns 10% or more of the corporate applicant. The commission can decide, yes, this applies, or no, this doesn't apply. It's not a lot of factors, so it shouldn't take too long for most of them. And then if there's a factor the commission wants to have a discussion about, we can stop on that factor and have the discussion. And that seems to me to be the most efficient way to walk through the mandatory and the discretionary qualifier factors.
Yeah, I like that. Start with the mandatory and then just make sure that we all are looking at exactly the statutory and regulatory language.
Absolutely.
Okay, because we want to make sure it's very precise. Thanks.
So again, we'll start with Mr. Carney, and then once we get through that, we can go on to the trust. So the first mandatory qualifier factors are in Chapter 23 and Section 5B.
Just
And
one
that's,
second.
yep.
Okay. I don't know if that the commissioners, you
Are we
need
all
more
there?
time?
Okay.
Not
So
yet.
state-
Just give me
Oh,
a
sure.
Yeah.
minute. All set. Thank you.
Great. Okay, so that section states, for the purposes of this chapter, the following shall be considered to have control of an applicant. And again, we'll walk through them one at a time. One, a person who owns 10% or more of a corporate applicant, provided, however, that a bank or other licensed lending institution that holds a mortgage or other lien acquired in the ordinary course of business shall not be considered to have control of an applicant. So I'll pause there and ask if the commissioners believe that this provision applies or not to Mr. Carney.
Commissioners?
Okay, hearing nothing, I'll move on.
No, I think you saw people were
It's no,
not,
yep.
they were going no. Okay.
Understood. Yep. Two, a person who holds a beneficial or proprietary interest of 10% or more of an applicant's business. All right, I'll move on unless someone asks me to pause.
So commissioners? Do you have any questions? I see Commissioner O'Brien is asking.
Well, isn't it a dual? Is it a dual here, or am I reading this incorrectly?
I apologize. I'm not sure what you mean by a dual.
Doesn't it keep going?
A little longer than
There's
that.
an and, right?
Oh. Let me pull up the,
on
excuse me, I'm reading from my
On two?
notes, so give me one
5B2,
second.
there's no and. I think ultimately there's an and. All of these are and we are going to have to decide it. But they're all no. The purpose of this chapter, the following shall be considered to have control of an applicant. So one, I think we all recognize no. Two, person who holds a beneficial or proprietary interest of 10% or more of an applicant's business. Commissioner O'Brien?
Yeah, I guess the version I'm looking at of the legislative page says a non-corporate applicant's business operation and who has the ability to control the activities of the non-corporate.
Is that
Sorry,
the amendment?
Commissioner O'Brien, you're looking at an older version.
Yeah.
of-
Oh, okay, so the
of
legislative
statute.
on the website is the wrong version.
Yeah,
It's one that's
Got it.
posted.
Been amended, yeah.
Got it.
Okay.
We'll give you time to find the right version, Commissioner O'Brien.
and I can circulate it, but I'm having a little trouble with my Westlaw, so I might need a moment to.
I think everybody's got the information in either hard copy or online.
Are we good to move on then?
Yeah, I think they changed it last year, did they not, Caitlin?
That's correct.
Yeah.
Okay. So the next is if the applicant is a corporation, which is the case here, the A, president, B, chief executive officer, C, chief operating officer, D, chief financial officer, E, treasurer, F, secretary, G, each inside director, and H, chair of the board of directors. So I don't think any of those apply, but we can move on. Okay, so
Is
those
everybody
are
in
the,
agreement? Because this is a good time for us to sort of be making our decision making or asking any questions. So that's why I'm looking to see, is everybody in agreement that's a no? Okay,
so from there, we're going to move over to the reg, which is 205 CMR 215. And in
and that's
particular,
because item number 4 doesn't apply, and I just want to make sure I'm being really thorough.
Absolutely. Yep.
On 5B, 4 and 5 don't apply.
I don't believe that the applicant is an LLC or a partnership. So
Okay.
if that's wrong, please jump in.
Okay, and MGA's here. If there's something that they know that we're just missing, I'm counting on them for an explanation. So 5B is all set then. Now we turn to the reg. Okay.
Yes. Now we're looking at 215 and in particular 215.02 subsection 1. I'll give everyone a moment to get that.
215.02.
Yep. All right. I'll move on unless, okay. So that states that the following persons shall be required to qualify as part of the sports wagering license review. If the applicant is a corporation, again, I'm skipping over to the corporation piece of this. If the applicant is a corporation, each officer, don't believe that applies here, each inside director, any person owning or having another beneficial or proprietary interest in 10% or more of the common stock of the applicant or holding intermediary or subsidiary company of such company. Okay, I'm going to move on to the last factor, which is in the judgment of the Division of Licensing after consultation with the Bureau, any person with significant and substantial responsibility for the applicant's business under the jurisdiction of the Commission or having the power to exercise significant influence over decisions concerning the applicant's operations in the Commonwealth.
Discussion on this, Commissioner O'Brien.
So is this discretionary or mandatory? I
This is
'cause it says
mandatory.
in the judgment of.
So if in the judgment of the Division of Licensing after consultation with the Bureau, they believe this applies, it would be a mandatory
Then it's mandatory.
qualifier.
Have we heard anything from Chief O'Brien on this?
Well, Chair, the chief consulted with the IEB, and in this case, the chief set herself aside from this particular application, but we worked with the licensing manager on the designation here. Based on the submissions, the representations, the IEB and licensing did designate both the trust and Mr. Carney. And at a particular point in this process, when suitability issues arose regarding Christopher Carney, the IEB declined to disturb that. But now the matter is before the Commission again. But for all of the reasons that the IEB has explained in its filings, those two qualifiers were designated, and at the time that we were asked to adjust that designation, we declined to do so.
Oh, I understand that, but now we're looking at 02 subsection 1A4. So, Commissioner O'Brien, you want to go through that question?
So I guess the only follow-up question then in that regard is, as we've gone through the hearings the last several weeks, is there any change in the position? In terms of, are you taking the same position still?
I
On
don't
that
know
point.
if we've seen a position taken from IEB.
Well, the declination that they made the request in the first instance to be de-designated or withdrawn to them, and that was declined. And so my question is, you know, is that the same position, given that there's been some new information that's come forth?
The second clause of that subsection, you know, after the or, you know, having the power to exercise significant influence over decisions concerning operations in the Commonwealth. In terms of the connection to MGA, the overall company, the IEB continues to have some questions there, including our ability to rely on some of the assurances that have been made given the discrepancies in the production of some of the materials that we saw and the reality that we identified that was in conflict with some of those assurances.
Commissioner Maynard.
Can I ask the question in a slightly different way, Director Lilios? Same question as Commissioner O'Brien, but let's say that the commission is to take all the facts the applicant says as true during the last few meetings. Would we would you have a different recommendation?
Taking all of the assurances as true with this particular mandatory factor, I would have more confidence in lifting of the designation.
And then I
would like to be heard, Commissioner, and you know, may have something helpful on the discretionary factor.
Okay, thank you.
Commissioner
And
Maynard.
that in particular, because I hadn't been thinking of it as going to this second clause, but you know, setting aside the adjustments in the trust that you have heard about, there remains the interest in BAS Holdings and the track in the trust that you may want to give attention to.
Chair, can I be heard momentarily?
Yes.
It is absolutely impossible for an applicant to continue to respond to what I think is basically a sliding scale of what we should be considered and what should be considered for purposes of being an applicant. The bottom line is this, that Chris Carney was identified as a qualifier because of his beneficial interest in the Christopher L. Carney Trust. That's what the report concluded. That's what it was based on. We've taken every step that we can to try to alleviate and remove all of those particular interests. But we can't continue to then say, okay, fine, what about this? Okay, fine, what about this? We have done everything that we possibly can in order to remove Christopher Carney, certainly under what we think is the appropriate standard limited to the statutory requirements here. And now to essentially have to, I guess, now respond to additional reasons for qualification puts any applicant in an absolutely impossible position. We will work and we will try to address any concerns that anybody has regarding the status of our application, regarding any conditions that need to be put in place to ensure that Christopher Carney doesn't have a role that causes any concern for the IEB, but more importantly for the commission. And we're happy, certainly it's been our intent to attempt to do that over the last several days, but we can't continue to try to fight essentially something that appears to be changing almost sort of meeting by meeting.
Commissioner Nozal, I appreciate your frustration. I guess I don't have anything in front of me from my perspective in the IEB reports that show, other than newspaper, and this was decided on or presented to us on Friday, concerns over ability to influence decision-making. And I raised that. And what I haven't seen is in number 4, I think I don't have anything in front of me that says that Division of Licensing, after consulting with the Bureau, has that finding, that they've made a finding that either Mr. Carney will have significant substantial responsibility for the applicant's business under the jurisdiction of the commission, or has the power to exercise significant influence over decisions concerning the applicant's operations in the Commonwealth. You've raised questions for us to consider, but I don't have anything that shows that supports that finding.
I would
and I
disagree
say
with
it
you,
because
Madam Chair.
I
You
say
just
it-
stated it on the record.
Hmm?
I would disagree in that I think the procedural posture is there to put that out. And then I just put the question definitively to IEB whether the head of licensing has withdrawn from the application.
But do we have it as a finding in the reports anywhere that either of those have been met?
I think as a matter of law, as Director Lilio stated, the decision was made sort of moving into this, that they were a qualifier. And so that could be the baseline decision. And then it's now the commission's decision to sort of evaluate and move forward on that.
And then the IEB declined in the initial instinct to act on the request to withdraw, which is another evidencing of it.
Again, that was before we took the subsequent actions in order to remove what has been identified as the reason Christopher Carney is a qualifier, because of his beneficial interest in a trust that owned 40% of the MGA stock. We have done everything that we can in order to remove that and remove any statutory requirement. And I would suggest, to the extent that there is discretion to go beyond what the statute is, that there is no evidence of anything else that's before the commission at this point.
Let me just add that to be clear, I believe that the commission in evaluating this factor should take into account the statements of MGA and sort of how it intends to move forward. But I do believe at this point in time, the commission can make a decision on this factor. That's all.
If I may, Madam Chair, I would just ask the commission to recognize also the explanation that we gave the other day, that our Supreme Judicial Court has issued decisions over 100 years in age, that the only control over a corporation in the Commonwealth is exercised by its actual directors, officers, and to a limited degree, shareholders. So the IEB made a qualifying decision based upon the trustees of the trust, not Christopher Carney, but the trustees of the trust being shareholders. Not because they were officers, directors, or even shareholders. We've eliminated that. So we would ask the commission to recognize and apply the Supreme Judicial Court's constant and consistent holding as to who controls a corporation. But we have satisfied that, whether it's discretionary, whether the commission wishes to consider this a discretionary or a mandatory issue. As a matter of law, enunciated multiple times by our Supreme Judicial Court, only officers, directors, and to some degree shareholders have any measure of control over this corporation. And we've eliminated that completely. So I would ask that you please take that into consideration.
Commissioner O'Brien?
Okay, I think I've made it pretty clear. I disagree with that representation. I'm looking at 23K, 23N in the regs, and I just think that's a patent misrepresentation of the status of the law and authority of this commission. I would also state that to the extent that maybe people feel like the ball is moving and the rules are changing, there has been a drip of information that has come out of the applicant that's always constantly changing the facts on the ground. That to me is more the reason that we keep having to come back, rather than anything that IEB did in terms of misrepresenting why Chris Carney and or the trust are qualifiers. So I struggle to move forward past 215-021A4 being anything but mandatory, given the facts before us. I can speak again when it comes to discretionary, but I have looked at what was submitted by IEB. I went back in addition and I looked at the motion to withdraw, and I looked at, in particular, Chris Carney's own words in the March 17, 22 Rainham public hearing, the November 22nd, 2022 podcast interview with Bloomberg, his statements to IEB in May of this year. And in each of those circumstances, it is replete with representations that he is integrally involved with these businesses, that he has the authority to, could have closed them down in his own words. And when I asked him pointedly, close down what? He said the dog track, which we've had further discussion today, is sort of part owner of the simulcast licensing business that is the genesis of this application. At the public hearing in Rainham, he spoke up and not only did not dispute that he was there on behalf of MGA, but then had an exchange with a resident, very specifically saying, I'm the person, come to me, here's my cards, call me. I haven't had the arrests in 30 years, et cetera, et cetera. When he got into the Bloomberg, and I note in that hearing too, there was a question about addresses of businesses. And Chris Carney himself was rather knowledgeable about the level of activity inside the sports book, the traffic in and out of the facility, and also going so far as the nuance of potentially changing the address and the impact that it would have not only on the simulcast, but also the liquor license of the facility. So when I look at that, I look at his representations to Bloomberg, where he said that their first partner, Bet365, where he came out and said, it's a family business I felt very comfortable with when I talked to them when I went to Vegas, et cetera. There is the effort to simply look at the four corners of paperwork. Then there's the reality on the ground and the evidence in front of us.
So Commissioner O'Brien.
Let me finish, Madam Chair. So from where I sit, the question on 215, 0.01 on the 4, to me, not only was he acting as an agent and the ability to influence, but he was the point person for this. He went out, in his own words, totally apart from whether or not newspaper articles are misrepresenting. Chris Carney's own words put him at the core of this. And I cannot say on the evidence before me as a commissioner that good cause has been shown. To me, it's mandatory on this record. And I can talk about whether good cause discretionary comes on that set of facts, if we want to defer on that. But I was struck by his own words and the evidence that was put in front of us. I can't reconcile it any other way.
So I agree with you, Commissioner O'Brien, that Mr. Carney's words are very much reflected in newspaper accounts as him having a perceived ability to control and influence matters. However, I'm not sure we have any evidence that the individual or individuals who actually had control authorized him. The fact
Madam Chair,
excuse me, 1 minute.
It's not the newspaper articles, it's the defendant's own representations as an apparent holding himself out publicly into government entities that he was the agent.
Agree.
I think that needs more vetting by this commission.
I agree with you that he is, and this is, how I feel. I do feel there is sufficient good cause here for granting these two, but we're speaking about Mr. Carney's request for withdrawal. I did look at those articles carefully. I do see Mr. Carney is holding himself out. What I don't see is that we have evidence or information from other than those newspaper accounts and Mr. Carney himself that he actually has significant power to exercise significant influence over decisions concerning the applicant's operations in the Commonwealth. What I do have is I have a history of this particular applicant working with us as a simulcast licensee, where the individuals who are in control were Mr. George Carney and then, of course, Sue Rodrigues. There hasn't been any confusion on our part as to who we are working with. And Mr. Chris Carney may have a perception of his own influence, but when it comes down to actual control of the corporation, we don't have any evidence that he would have controlled those decisions. Is he a connector? Perhaps. Does he work to support the family? business, yes, but there's no contracts, there's no indication that he has control. I do think
That's the problem for
it
me
is
too.
that we are working hard to try to see him as inextricably intertwined. I just am not there based on newspaper accounts. I do know that there's a big risk if he was and is, and the applicant ever gets to having a durable suitability found in a full license. There's a big risk if anything that I'm saying and seeing is in any way contradicted. And that would be, of course, our ability to assess a fine or to actually revoke the license. At this, juncture, I see, our director of racing, Alex Lightbaum, Dr. Lightbaum, who 31 years, has worked with Mr. George Carney. We have no indication of any kind of problems or concerns raised with respect to this particular applicant, including anything with respect to Mr. Chris Carney. No negative history or non-compliance that has anything to do with Mr. Chris Carney. We actually have IEB having found Mr. George Carney, apparently Mr. Kelly, suitable in 2013, 2015. And yet, if he was still, Chris Carney was still inextricably intertwined, you would think that they would have found that, and yet we don't have any evidence. Now, they may, when Director Lilios's team goes through all that they need to do for durable suitability, they may find something that actually lends the support to their argument today. But my job, from my perspective, is to strictly look at the evidence in front of us or the information in front of us. And what I'm seeing and hearing is strictly in newspaper accounts or from Mr. Carney, whom, as I said on Friday, may suffer a little bit from loose lips, and sometimes I do too. But I am saying suffers from that, but that's a perception and not necessarily real. So we could, of course, under our consideration, and I know we're going to get to this, have a condition to address your concern as we think about this withdrawal, because even withdrawals can be conditioned.
So here's my concern with the recitation you just gave, Madam Chair. You keep trying to take the undisputed statements of Chris Carney and question the veracity of them by casting them as if they were newspaper articles. I did not talk about newspaper articles. I am talking solely about his own words. And this is a company that, if it's his loose lips, this company allowed him to go to government bodies and represent himself as the agent of that company. Now, I have an issue with that if that's going to be the explanation for loose lips. In addition to that,
that's not the
my
explanation
issue,
of loose
let me
lips,
finish.
no.
In addition to that, Madam Chair, the reason, you called out to Director Lightbound the status of what IEB was tasked with doing at this point under the reg, and I expressed hesitation with this early on, was overly reliant on self-reporting by the applicants and an open source check. They have not done what is traditionally done. And that's the other concern that I have with that, which is why the posture that we're in, given the drip, drip, drip of information, et cetera, coming out of the applicant, I think the request to designate and withdraw is premature. I don't think this is enough. And on the record before me, I patently disagree with you. I think that the evidence, the substantial evidence, it counters good cause. I think the good cause is to keep them designated and to go forward and determine both historically what was it for business practices and would he be a qualifier, and then assessing the veracity of the structure going forward, where you have he was going to be COO and all these people were reporting up to him, and then you just eliminate the position with no succession replacement. I have a huge issue with that. I welcome my other commissioners' thoughts. I really would like to hear what they have to say.
Madam Chair, may I address Commissioner O'Brien's concerns?
Respectfully, I'm not asking you at this point, Attorney Maurizio. I've asked to hear from the other three commissioners.
Before we turn to the other three commissioners, would you like to offer Attorney Maurizio the opportunity to, he did ask me if I would allow, and my instinct is to allow somebody to speak, but Commissioner O'Brien has said no, so I turn to you. Should we have Mr. Maurizio speak or no?
Yes.
Commissioner Maynard?
I'm perfectly fine with that.
Commissioner Skinner?
You have consensus. Chair.
Thank you. And I appreciate that, Commissioner Skinner. I do think it's important for us to all be able to speak. Go ahead, Attorney Maurizio.
Thank you. Members of the commission, I appreciate Commissioner O'Brien's concerns. I'm not trying to eliminate them or challenge them. But what I would like to point out again is the superseding events which we have taken to eliminate or address those concerns. Commissioner O'Brien, you've correctly pointed out what Chris Conni's public statements have been. Those are his statements, and many different inferences can be drawn from them. But I think, as I pointed out the other day, that when those statements were made, Christopher Conni was doing two things. The first was what he has always done in the construction realm of MGA's activities. And if the commissioners recall, Christopher Conni explained himself directly, very well, I think, on all of his activities in the construction world. Nothing to do with the simulcast business, strictly construction, tearing down the buildings, fixing the roof, the HVAC equipment, preparing the site for the new building, et cetera, et cetera. Even the activities connected with obtaining site plan approval from the town of Raynham is all construction related, and it was all done even before 23N was passed. The second important fact that's now been corrected is that Christopher Conni's a layperson. He's not an attorney. He doesn't understand the distinction between the stock that was put into a trust that's owned by the trustees and not by the beneficiary. As any layperson would assume, that if you're the beneficiary of the trust and a trust owns shares in a corporation, you consider it yourself to be an owner. That's very understandable. But as a matter of law, that wasn't the case. So all of these events that are being pointed to were prior to our corrective action, which we've now submitted to remove Chris Conni as a qualifier. He is his trust, the trustees of his trust are no longer shareholders. There's no money that's going to flow, even though that's not under the law or the regulations by itself a test for qualification. But we have made sure that in the divestiture of that stock, that no money from the Category 2 sports betting activity would ultimately work its way to Christopher Conni. That was just an added step. We don't believe it was necessary, but it was just something to give the commission a clear understanding of how far away from the Category 2 sports betting license Christopher Conni will be. And lastly, with all due respect to Commissioner O'Brien, what constitutes a control over a corporation is not up to me to say, nor is it up to anyone on the commission to say. When the Supreme Judicial Court has ruled on that issue, and when the legislature has passed 156D, which governs all corporations or Massachusetts corporations and their control. So it's not, there's no evidence to provide. It's a matter of law, determined not by us, but by the SJC. So I would hope that the commission understands what I've just outlined, and I hope what I've explained addresses Commissioner O'Brien's concerns. We've cured Christopher Conni's perceptions of ownership, and we have put a bulletproof wall around him in a manner that meets the SJC's rulings and 156D about control of a corporation. He has no control. In fact, he has no financial interest. In fact, and all concerns that we can understand have been addressed. Thank you.
One thing is specifically not in there. First of all, again, we don't have to spend the time doing it. I patently disagree with you. 215.021A4 has nothing about control. It is the power to exercise significant influence over decisions of the applicant's operations, which is sports wagering. The striking thing to me is that the argument for dispute, for just disregarding that, would be that the company was so derelict that it allowed someone to represent themselves, and that was fine with them, and it's puffery. But most striking to me is November 22nd of 22, months after sports wagering is passed, Chris Carney makes representations publicly that I have never seen disputed, that he went out to Vegas and negotiated with Bet365. He makes representations about negotiating the operations agreement with Caesars. So to me, I have a number of questions that to me kill a claim that good cause has been shown on this record.
So Commissioner O'Brien raised an important distinction. You are using the term control, Mr. Mauricio, and under 4, that's where I'm saying, I don't see it. Commissioner O'Brien sees it differently in terms of the power to exercise significant influence over decisions concerning applicants' operations in the Commonwealth. So reduce the word influence is what she's focusing on. I don't mean to repeat her words because she said them clearly, but that I'm hearing you say control, and my fellow commissioners are thinking the same thing.
I've used the word control because they're in section 5B of 23N, and it's in your implementing regulations. But the SJC doesn't limit their opinion to control. The citation, I can give the commission another citation from yesterday. Halbian versus Berg, 457 Mass 620, pages 624 to 625. It was a leading decision discussing the new implementation of 156D and what positions, what persons have the right to do anything, control, influence, whatever verb you wish to use. The SJC made it crystal clear in that confirming decision that certain officers and directors, and to some extent shareholders, are the only human beings that can control or influence or direct or cause a corporation to act in any way, shape, or form. There's an amicus brief filed with that case by the co-chairs of the 50-lawyer committee that worked approximately 10 years on coming up with the new chapter 156D, which governs corporations. The amicus brief gets into exactly what we have said, that unless you sit in one of those positions, you can't do anything with respect to a corporation. It's akin, if you will, to the commission. Each one of you have certain authorities based upon the position you hold as commissioners. Somebody else in the Massachusetts Gaming Commission could have an opinion about what their authority is or isn't. But it's an authority determined by the position you hold, not by the words you use. It's the same with a corporation. And that's what the SJC has said. And we're all, I would respectfully submit, bound by the SJC and by chapter 156D when you're examining what human being can control or influence or direct a corporation in this state. There's just no gray area about that. That's just the law as it is.
And yet Mr. Carney, Chris Carney, is going and signing PNSs. He is signing formal documentations to public bodies representing MGA. And the MGA was totally fine with that. And respectfully, if this body or any other adjudicatory body were restricted to paperwork, I shudder to think what suitability analyses would look like if you couldn't look at the actual facts on the ground. We are tasked with looking at the facts in front of us, not a tortured analysis of corporate law that tries to hamper this commission.
I don't, I'm sorry that you've expressed it that way, Commissioner, because I'm trying not to be in an advocate position or an adversarial position. I really am. But you're describing a tortured analysis. It is the law. And to some degree, you seem wedded to certain events that all happened before we submitted our withdrawal request, where we have, as a matter of law, ended all of that. That's yesterday's history. The last superseding event that you have is that the Chris Carney Trust, the trustees of the Chris Carney Trust are no longer shareholders of MGA. They're not. Chris Carney never was, but they're no longer. You have the legal documents that demonstrate that. That's not a matter of opinion. That's not a matter of advocacy. That is not a tortured explanation. That's a legal reality. And the other legal reality is Christopher Carney is not an officer, director, or shareholder of the applicant. As a matter of law, he cannot influence the corporation in any legal sense. Can't do it. Those are the realities from the point in time in which we submitted the withdrawal request to today. And we would simply ask the commissioners to look at the curative steps that we took to eliminate this question. We have eliminated any possibility of Christopher Carney controlling, influencing, or any other verb you wish to think of, the direction of MGA from the point of today into the future. And we would hope that that would be enough. Thank you.
Can I ask this question? Mr. Rizzo, under your analysis, the corporation could have authorized Mr. Carney with, respect to his expertise in construction and planning to represent the corporation without ceding authority to him. Is that correct?
Of course. I mean, the engineer who put together the plans for the site plan approval, it's a zoning step. They
Okay.
routinely handle
And my
that.
quick follow-up question is this: if we had a condition to the request for withdrawal, you could have a condition that says, even though that's permissible, going forward, the corporation would not authorize Mr. Carney to so represent the corporation or the company, even in matters in which he has that construction expertise, that you would cede that to some other individual or entity. Could that
Well,
be permissible?
I represent Mr. Christopher Carney and the trustees, and I know they would agree to that, but it's up to MGA, and I'll allow Mr. Nozel to answer that question.
Chair, yes, we'd agree to those conditions.
Right. And then to Mr. Carney, would he agree to a condition that he not make public appearances and public statements, or public appearances in which he makes statements or in any way makes public or private statements suggesting that he has authority, perceived authority, or express authority? Would he be willing to a condition of some sort? That wasn't very artful, forgive me.
I know he would agree to it. It gets to be a little difficult to envision every possibility, that some question may be thrown at him someday. But I mean, Christopher Carney has already said that he's not going to be involved. He's going to follow the commission's decisions and conditions, whatever they happen to be. He's more than happy to do that.
Councilor Grossman, you just turned off your microphone.
I was just going to suggest that we would have to refine that principle if that were to become a condition, in that if Chris Carney were no longer a qualifier, we couldn't control his actions.
Right.
It would have to be the other way around.
Right.
That we could control MGA and what would happen if Chris Carney was out there making certain statements.
That's right. Thank you. Okay, commissioners, I took too much of the time. My apologies. Commissioner Hill, Commissioner Maynard, excuse me, Commissioner Skinner. And Commissioner O'Brien, you have your microphone off. Sorry, you probably wanted to follow up. Commissioner
No,
Skinner?
I'm still looking forward to hearing what the other three commissioners have to say.
Okay, Commissioner Skinner?
So I share Commissioner O'Brien's analysis under this particular question, 215-021A4. The notion of Mr. Carney having the power to exercise significant influence over decisions concerning the applicant's operations in the Commonwealth, that is still an open question for me. I said this last week. Chris Carney is very much ingrained in the family, the culture, the community, and where you have this almost, I think Mr. Carney made statements to the effect of, he's been doing this all his life. I wonder how he'll be able to shut that off. Attorney Maurizio, you indicated that it would be hard to envision every single circumstance where Mr. Carney might be called upon to speak on behalf of MGA, where he would have to refuse. And I don't want to put words in your mouth, but that's my interpretation, that he would agree to do that, but it would be hard to put that into practice in a lot of ways. And I share again, let me finish and you will have the opportunity to respond. But I share that opinion that it will be very hard. And, it's convenient to rely on Massachusetts statute and case law where it benefits the applicant who finds itself in this predicament, whereby it's needing to convince this commission that Chris Carney does not have actual authority to make decisions on behalf of MGA. But I think it's already been said that his own statements, newspaper articles, the way he's held himself out on behalf of the corporation suggests otherwise. And Commissioner O'Brien pointed out the fact that there hasn't been anyone appointed in Chris Carney's place to handle these kinds of matters on behalf of the applicant. Specifically referenced was his negotiation. And I, again, commented on this last week. It's the inner workings of the operation, the sports wagering operations, that we really don't have a lens into. We really don't have an understanding beyond the representations that you've been making over the past couple of days, exactly what Chris Carney's role will be. And again, you're suggesting that there will not be any role, but it's hard to separate and really envision, right? Where, a situation where he is just completely removed from the family, right? Completely removed from the community and not engaging in any iota in MGA's operations. I promise I'll give you an opportunity. Let me finish, Attorney Maurizio. So there's this notion of actual and apparent authority, and certainly, from your perspective, there's no legal authority from Chris Carney to have done, to have set in motion all of the things he has set in motion relative to MGA. But there's definitely a apparent authority. And who's doing all of this, if not Chris Carney, right? There's been no representation as to who will take on these responsibilities in his absence. And I think that's very important. That needs to be established. It's very important. Relative to the actual, you talked about curing the perception, and that it's your position that MGA has done so. I disagree, because, the very points that we need to be hearing about is, what will the structure be going forward? Who will handle these matters on behalf of MGA going forward? Have not been spoken to. Relative to, I'm sorry? Okay. Relative to exercising significant influence over decisions concerning the applicant's operations, I think that Chris Carney is a mandatory qualifier. Now, that being said, based on all of the representations that were made today in terms of extricating Mr. Carney from the operations, I think that, to the extent that there's room, and I don't know if this is possible, but, the discretionary aspect that Commissioner O'Brien referenced, I don't know if a waiver is appropriate here. If so, to the extent that there is that discretion, I'm interested in giving the applicant the benefit of the doubt, because I think there has been significant work and preparation put into opening and establishing and operating, a sports book on the property. And so, I want to be clear, though. I think that as a fundamental question, I do think, and I do want to rely on IEB's determination that Chris Carney is a qualifier. And relative to the process that this commission has set up to determine preliminary suitability, we have the IEB's report, and it does not contain recommendations. Director Lilios has reminded me in particular, in public, time and time again, that that's not what IEB is charged with doing. It is up to this commission to make those determinations, certain determinations relative to whether or not a qualifier is preliminary suitable or an applicant is preliminary suitable. I think based on all of the, the totality of the evidence, yes, Madam Chair, I'm going to use that word, but I understand it's a loose iteration of that. I think that, there is a question still, and it's certainly the perception. And I understand what your argument is relative to reality, but there's certainly the perception that Mr. Carney does continue to have and will continue to have the power to exercise significant influence over decisions concerning MGA's operations.
Thank you, Commissioner Skinner. I understand exactly what your thought process is. And I can't question it, except to ask you and the remaining commissioners to look at the past a little more carefully. Because the IEB report and everything that you've been talking about as to what Chris Carney did in the past began in the context of the sports betting legislation hopefully being passed and preparing MGA's real estate for development. If you consider the evidence or the facts that have been presented, even in the IEB report, nothing on Chris Carney now, nothing predates that activity when Chris Carney was a shareholder, his trust was a shareholder of MGA stock. That was a recent, relatively recent event due to Mr. George Carney's estate planning. And then the construction activities that Mr. Chris Carney is very knowledgeable about. Dr. Lightbaum told the commissioners that for the years and years and years that she's represented the old State Racing Commission and now the Gaming Commission and dealing with MGA's activities, it's been George Carney, Sue Rodriguez, and Joe Capucci have been the points of contact. That is the information you have. And it's only when 23N comes into play, and now MGA has to now rechange the way it operates. There's a great big old building that's been there, since 1929, 1930 for live racing. It needs to go away. And we needed to create a brand new facility, state of the art, the biggest apparently in the sports betting world that ever existed, is what I hear, and move in that direction, which required zoning, site plan approval. It's a construction task. It required, actually sending the bulldozers and the excavators out there to do the work. All of that began, Chris Carney's activities began when that effort began, nothing before. And there's no facts that have been submitted that suggest he had any involvement in anything prior to that coming to light. So now that's the past, which now, and we've talked about it many times, how we got there. So now we've submitted a request to withdraw. It's not a matter of will MGA follow what it says it will do. It's what MGA has been doing for decades without Chris Carney's involvement. He only stepped in for construction, and then when he thought he was going to be an owner, then was proposed to be the COO for a period of time. So I think, and I can understand how the commission is focused on the last year and a half or so. But MGA has been in the gaming business under Mr. George Carney's control, ownership since for the past 57 years, but he was involved in management even before he took control of the racetrack, going back to 1956. That is the reality that we're faced with. Mr. Carney, George Carney, has always been the boss. Nobody tells George Carney what to do, not even his son. And we've presented you with the papers to take care of the last year and a half to 2 years that have happened. And we believe we've done that fully and completely. As to your concerns, Commissioner Skinner, as tomorrow and going forward, that's outside my role at the moment. Yeah, Mr. Nozel is able to talk about that. And I understand there've been org charts submitted that explain it, but I'll turn that over to Mr. Nozel.
Commissioner,
Can I just comment on, just comment on a response to your comments, Attorney Maurizio? To be clear, I'm not limiting my opinion that Chris Carney may have, significant influence over MGA to the news articles relative to his connection as COO of the sports book. I, in large part, make my determination, my opinion, based on his identity as a family member. Particularly where you have a corporation that is in all of the filings over the years. I mean, it's primarily, and I don't think anyone disputes this. It's a family-owned business where you have family members, primarily holding significant roles within the corporation. And so, that's the practice, that's the history of this corporation. And how do you exclude Chris Carney from that? How do you exclude Chris Carney from the family, right? That's not easy to do, right? So it's from that perspective that I am forming my thinking around the perception that Chris Carney may continue. I want to be careful with my words, may continue to have significant control over the corporation if this commission does not put safeguards in place to prevent that.
Fully understood, Commissioner Skinner. Not to restate what we've said before. Christopher Carney is more than willing to accept whatever conditions the commission deems prudent. The only thing I would continue to hit home on is the undisputed fact that this company, MGA, has been under the control of George Carney for decades. And throughout that time period, Chris Carney has still been his son. And other than the construction activities that kicked in order to get this sports betting operation going, Chris Carney has not, and there's no evidence to the contrary, been actively or in any way exercised any control over the applicant. This just hasn't happened. I mean, to suggest that Chris Carney is going to control George Carney is to, with all due respect, is to not understand the 50, 60-year history of George Carney. George Carney's his own man. He built this company himself. He relies on experts, he listens, he takes advice from lots of people. And then he makes the decision. He's in charge. He's always been in charge. That'll never change.
And I'll just be very sort of brief on behalf of the MGA team. MGA is certainly willing to accept conditions that alleviate any of the commission's concerns going forward. And Commissioner Skinner, we have put the team as it exists today, as we propose, if in fact we have the ability to move forward here in front of that commission. We put it together and put it in front of the commission in connection with our initial presentation we made in connection with the application. You heard from a lot of them, and actually all of them are here around the table today. And I indicated before that is in front of you as Exhibit B to Exhibit 15 of the original report, where we removed the COO position, but that's our organizational structure. Are we open to discussions about how that organizational structure could be, potentially enhanced? Sure, but we have put the team that we expect is going to run this going forward in front of the commission. And I would say that team successfully went through a majority of the elements that was certainly required as part of the application process. You heard from many of them, Mr. Brooks, Mr. Joe, as well as Sue Rodrigues, and as including others that we've added since we're going to be now part of a sports wagering enterprise, including other people that are here today, Mike Michno, Kevin Regan, security and surveillance, as well as, security and surveillance. So we've been building that team out, and we have presented what that team is going to look like to the commission going forward. And we feel confident without that COO position, and certainly without Christopher Carney, that this group can successfully operate a sports wagering operation.
Can I turn to Commissioner Maynard or Commissioner Hill? Are you interested in commenting at this point? Well, Commissioner O'Brien responding? Did I miss somebody? Oh, okay.
I didn't know if Brad wanted to go or if I want to go.
I couldn't tell which way your hand, you were motioning to Commissioner O'Brien.
Yeah, I think it's Brad.
Commissioner Hill?
Commissioner Hill?
Commissioner Maynard.
Go ahead, Commissioner Maynard.
Yeah, so I feel like this has been broader than just the singular question of the particular clause, so I might as well just get it out there. One of my mentors and good friends and somebody I look up to said, just because you put boots in an oven doesn't make them biscuits, right? And I feel like I've heard a lot of boots going into the oven, right? And you're looking in there and there's no biscuits, right? And so the way I'm looking at this is, I believe on the day that the IEB took their information, I think they were totally correct in their interpretation. I think that the way that they were looking at it, I don't even question it, that, there should have been, he should have been listed on the document. There's Chris Carney. There's no question. I think that Commissioner O'Brien, by the way, I just have to address this. I have to, Attorney Mauricio. I did a lot of research back a few months ago on what the commission has authority to do and not do, because we were actually having a debate amongst the commissioners on authority. And what I learned was the SJC gives a lot of authority to interpreting statutes and regulations to this body, right, when it comes to those under us. And so I just want to be clear. I hear what you're saying. It is a factor that I am weighing. I believe that all of us are. But at the end of the day, the buck stops with the commission until a court says differently on any particular decision that we make. And I think most bodies like ours in the Commonwealth have been extremely successful in front of courts, including the SJC, in interpreting their statutes and their jurisdiction. That said, I am swayed by the argument that there's a willingness amongst MGA and Chris Carney to sever this relationship and do so in a way that is acceptable to the Gaming Commission. And I think the question then comes is it good enough? What you're offering up, is it good enough for us? I think there's still some to be left desired. I don't know how much has come into the public and the private section, so I'm going to say this very carefully. I think it's interesting, the trustee situation and who are the trustees of the Christopher Carney Trust. And that's something that I'm interested in. But if you're telling us that you're going to make every effort going forward, not the past, going forward, to separate, I would hold, as Director Grossman said, the applicant to extremely high standard on what they're allowing, right? Who they're allowing to go and represent them. The conditions are probably not exactly what you would want, Attorney Nozel, but I can foresee myself agreeing to some heavy conditions. But I would think that this factor is met today, as it sits today, after 2 meetings of the conversation. I want to be clear, that's not where we were when Director Ilios's team was looking at it before. And I think it's a lot. I want to commend the IEB, because I believe that the IEB finding some of this information drove us to this outcome. And I think that that's a good thing, not a bad thing. We just want to make sure that every operator that's operating in the Commonwealth is doing so with the highest integrity. I hear both attorneys today telling me that that's their goal too for the applicant. And that's where I'm sitting right now, and that's where my head is.
Commissioner Maynard, I appreciate your comments, and I know you said sort of jumped ahead. Back to Attorney Monahan, if we have to look at number 4 as mandatory.
Yes, I think if the commission determined that if you sort of agreed with I'll read it again. In the judgment of the Division of Licensing, after consultation with the Bureau, any person with significant and substantial responsibility for the applicant's business under the jurisdiction of the commission, or having the power to exercise significant influence over decisions concerning the applicant's operations in the Commonwealth. So if you believe that to be true as of today, I think that would be I know that would be mandatory, that Mr. Carney be considered a qualifier.
I will go back. I think as of a week ago, 2 weeks ago, maybe, right? As of today, I don't think that's so.
Okay, thank you. Thanks for that clarifier. And then Commissioner Hill.
I won't belabor this point anymore, Madam Chair. If you're going to ask directly about question 4, I'm in the same camp as Commissioner Maynard. When we first heard the discussion a few days ago, a couple of weeks ago, I would have said absolutely he would have been a qualifier. But after the last couple of meetings that we've had, after hearing from the MGA, after hearing from Mr. Carney himself, I would have to say at this point that I feel that he would not qualify. But make very clear that if we're going to release him as an individual qualifier, I too am going to recommend some serious conditions upon that withdrawal. But if you're asking us for a answer to the question as of today and as of now, I would say that he would not qualify.
Under 4. Okay, so that's really helpful. And as I said, I think that's where I've been, and I was struggling with it. I hear Commissioner O'Brien feeling differently. Commissioner Maynard, you've clarified. Commissioner Skinner, I think I heard you were in agreement with Commissioner O'Brien, but I don't want to put words in your mouth.
Not entirely. I think Commissioners Hill and Maynard and I we've reached the same destination, but have taken two paths. I'm not ready to say just yet, again, based on the perception, general perception and Chris Carney's role as a family member on behalf of the corporation, that he does not hold significant influence over the corporation. So I'm not willing to disturb IEB's determination that he is a mandatory qualifier, Chris Carney. But I am interested in exercising any discretion the commission has in revising or making some adjustments to that determination or waiving the requirement that he be a mandatory qualifier.
So, Commissioner Skinner, thank you for that. And that actually raises a question for me. Councilor Grossman or Councilor Monahan, I guess I was thinking the discretion would go the other way. Is there flexibility around 02184?
I don't think there's flexibility there. That is sort of a mandatory factor. Where there is more discretion is in 205 CMR 215.022. That's separate. So I think the commission would have to decide, whether it believes that this factor applies or not, and then it can go on. If not, it can go on and address the discretionary factor. And then at that point, you're done with the qualification factors.
So, okay. So at this juncture, if there were a majority of us who found that for subsection 4, my apologies, was met still. And again, I think I joined Commissioner Maynard in articulating that it's not a question of IEB's decision-making based on its initial thinking. If it's now shifted to us, I still just don't have the information that would allow me to say that either clause is met. But I would add that I do know this is a preliminary suitability stage, and I mentioned that earlier. And IEB has capacity to uncover things that we can't anticipate. But at this juncture, I feel that I join Commissioner Hill and Commissioner Maynard saying it hasn't. But I don't believe it's mandated that Mr. Carney be qualified. And what I'm hearing is that can't be waived. So it would have to be a majority of us finding that he is disqualified, right? Otherwise, we would move on to the next.
I think that's right.
That makes sense, Commissioner Skinner?
It does. And in that case, I do find that Mr. Carney, based on my own assessment of all of the information IEB put forward, I'm not willing to disturb their determination. And so I do think that Chris Carney is a mandatory qualifier.
Oh, okay. So I'm thinking, do we need to vote on this at this juncture on this?
I don't think you need a formal vote. I think it's enough to say that, correct me if I'm wrong, there are 3 commissioners who don't think he's a mandatory qualifier under this factor, and there are 2 that do. Therefore, we move on to the final discretionary factor.
More discretionary. Okay, commissioners, are you all satisfied with that, or do you want a formal vote? This meeting is being recorded. All set?
No, I think it's clear where we all stand. I just to reiterate, I do think he's a mandatory qualifier. But I think 3-2 on a consensus, now we move on to the next part of the analysis on the discretionary.
Which is more discretionary. Okay, and thank you.
So the last factor to consider is under 205 CMR 215.02 subsection 2, and that is the commission may, in its sole discretion, require other persons that have a business association of any kind with the applicant to undergo a qualifier review and determination process. These persons may include, but are not limited to, holding intermediary or subsidiary companies of the requester. And again, the term business association is not a defined term in either the statute or the regulation. So with that, you can discuss whether you believe this would apply and you would want to apply it here.
This doesn't raise the term close associate, but you
It
mentioned
does
that.
not.
And now,
That's in the suitability section. So
okay,
that would be addressed if we move on.
okay, thank you. Because I know that has a particular definition. Okay. So business associate does not. You know what I was wondering though, Councilor Grossman, if you could refer us to the page in the Wynn decision where that got brought up. I couldn't find it in the PDF.
Sure, it's page 6 of the Wynn decision. I can show it to you if that'd be helpful. It's one paragraph.
Yes, please. It'd be helpful to me.
Okay. You'll have to pardon my highlighting. Granted, and I think it's important to remember, this was determined under Chapter 23K. It's very similar, though. There also was not a definition for the term there. So I think the principles are aligned, which is why I've raised this and I'm showing it to you now.
It's funny, it's not on my page 6. Huh. Interesting. Of the decision.
Make that a little bigger. Hold on.
Thanks.
Oop.
Well,
It is on mine, Madam Chair.
it is. It's funny. I pulled up the decision from. Right now, I'm seeing the Secretary of State's change of supplemental information. Just, I don't know what you're seeing.
Oh, your shared screen is showing that.
It is. I don't know if I'm unique in that, which would be weird.
Oh.
You did have it up and then it just shifted for some reason.
Is it not on anymore? All right, let me try it again. Sorry.
I must be looking at a different version, Commissioner Hill, of the decision. So as long as he makes it bigger print, I can read the screen.
How about that?
Great, that's it now.
Madam Chair, Commissioners, are you still, it looks like everyone is done reading it. Should I take it down?
Commissioners, are you all set? Look, Caitlin, do you want to walk us through the regulation?
Sure. So again, it's that the commission may, in its sole discretion, require other persons that have a business association of any kind with the applicant to undergo a qualifier review and determination process. So basically, the decision for the commission is if you believe that Mr. Kearney has a business association of any kind with the applicant, whether in your discretion you would like him to be considered a qualifier.
Commissioners? Commissioner O'Brien?
I don't think it's going to surprise anyone that since I thought he was mandatory, to the extent that he's not deemed mandatory, I absolutely would think he is, should be designated under sub 2 for all the reasons that I said before, which I'm not going to belabor the time that we've spent and repeat it.
And that's despite the withdrawal request that.
Correct. Correct. Because to me, and I said this before, I'll say it again, he is integrally intertwined. He has been, and unless and until that is clarified for me in terms of their business practices, which are critical to suitability, unless that's got more clarity to it, I cannot say that having him as a qualifier would do anything other than advance the interests of the Gaming Commission in terms of ensuring the integrity of the process and the licensees.
Madam Chair,
Yes, Commissioner Maynard.
I believe Director Lilios told me earlier when we were on a different factor that she had something to say under this piece. I was interested in hearing it before I made the decision on it.
Oh, thank you. Thank you, Commissioner. Just my suggestion on evaluating this discretionary piece is to go back and look at some of the financial entanglements and whether financial entanglements rising to the level of a business interest can continue to exist. We talked about them in some detail in the closed session, so I want to be cautious about what's said in open session. But that would include the ownership interest that the Chris Kearney Subchapter S Trust continues to have, including interest that may potentially lead to something involving a land sale and whether that is an entanglement of note to you. The extent of any interest in construction contracts that have existed in the past or may continue to exist, and to the extent you deem relevant any residual interests. There was some mention by the applicant about estate planning stuff, which may not be a business interest, but given the overall family nature of the business, you may want to consider those.
Commissioners? We did discuss the financial arrangements and under RSM's reporting to us. We did hear from Chief Chang. Do you have other questions on that in light of Director Lilios's comments?
Is it, Madam Chair, is it public? And I'm looking at the applicant.
This is, oh, sorry. We're in public session.
I understand that. I almost said another Southern saying that wasn't as nice. But is it public who the trustees of the Christopher Kearney Trust is? Or is that just?
Yes, we've stated those, I think, in the public record.
Mm-hmm. Yeah, I think that's also public documents, right?
That's what I was getting at.
I'm just going to say that I believe that we've discuss the two trustees. We've identified them, I think, in the public record already. So they are here today. Yes.
The reason I'm asking Attorney Nozel is because I've got this, it's in my head. And so I'm just going to get it out there. You've got a trustee for the trust who is an officer of MGA. Is that correct?
That is correct, Commissioner.
Commissioner Maynard, you want to elaborate? Because I don't have whatever's in your head. I don't have it in my head yet.
I see that as a potential entanglement, that MGA would have an officer who also is a part of the trust, the Christopher Carney Trust. I see that as a potential entanglement.
I can answer that question, Commissioner, by saying there are two trustees. One of them is not employed by MGA, not an officer of MGA, Mr. Daniel O'Brien. He's an independent CPA. And it requires both trustees to act when it comes to activities of those trustees. So one trustee cannot do something on their own, requires both.
Thank you, Attorney Maurizio. I just want to put it on the record. Part of what you want us to do and to believe is that this relationship, from a business perspective, no one's asking for the familial relationship that keeps coming up to be disentangled. That's impossible. But from the business aspect, to be disentangled. And so when to me, I'm not judging anybody's decision making, but if it were me, I would have trustees that had no relationship with MGA, no relationship with the business, but that's me, right? And so I'm sitting here trying to figure out how I'm supposed to think about this and weigh this. When again, I'm taking the leap of faith that you're asking us to take, that this is going to be disentangled and that this is not going to be an issue. So I'm just trying to take a leap with you. And this to me is a sticking point in my thinking.
Well, Joe Capucci is one of the trustees and he's a director of MGA as well. So he's already going through the qualification process and you'll be examining his suitability on your own. Daniel O'Brien, of course, is an independent CPA. He's not an officer of the company. So his decision process, of course, is completely independent of whatever MGA is doing. And both of those trustees, the Chris County Trust now, they have no legal connection to MGA any longer. They've divested themselves of the stock. So that's the way we were thinking through this. The fact that Joe Capucci is a director and still a qualifier, I mean, that's it's a fact. But as trustee of the trust, they have no connection. They can't do anything vis-a-vis MGA or MGA's business. That's been completely severed. They're no longer shareholders. That was our thinking, to give you that comfort. So just to pick an example, MGA wants to increase the number of directors it has. That's a shareholder vote under Chapter 156D. The trustees of the Chris County Trust, not being shareholders, they can't even attend the meeting. They have no vote. They have no rights. They're not there. It's as if, I bought shares of IBM on one day as a shareholder and I could exercise shareholder rights and then I sell the shares. I'm out. I can't vote or do anything with respect to the shares I used to own. So I'm hoping that that was our thinking anyway, to break that connection by selling the shares.
I might be the only one with this hang up, so.
No, I mean, my hangup goes obviously beyond that, which is it just evidences once again sort of how they're intertwined. I don't see any succession plan in terms of replacing him as COO. I don't know what the succession plan is if this passes to who is apparently the heir apparent. And so to me, I share not only that concern, but even deeper concerns that I feel like him being designated under the discretionary capacity serve the interests of the statute in this commission.
Commissioner Maynard, it's that helpful? Now, I'll turn back to Caitlin because I know the context of your question or inquiry was with respect to 215.022. I think I've got that right. And the issue around business associate.
All right, I'm
Yeah.
just going to state again, you have a person that works for the business as a trustee of the trust. That is an association in my head.
Attorney Nozzle, if you could help out here.
We understand where Commissioner Maynard is coming from. I think certainly as a condition, I can't speak for the trust, Attorney Maurizio has to, but from the MGA perspective of not having one of its officers also serve in that trustee capacity, we would be open to that change if that was something that would alleviate Commissioner Maynard's concerns. I can't speak on behalf of the trust or what the mechanics of that would be and how it would have to be done. There's separate outside trust and estates counsel to this. And again, I don't represent the trust, but certainly from the MGA perspective, we very much would be interested in that certainly as an option if it was something certainly that would alleviate your concern, Commissioner Maynard.
Well, I would echo that. I'm sure that, the trustee, if, Mr. Capucci is someone that the commission is not comfortable with because of the connection with MGA. Mr. Capucci can resign and then a new trustee can be appointed that has no employment position with MGA.
I did want to note that initially in the initial scoping, Mr. O'Brien was not designated as a qualifier for his trustee status, but as our documents repeatedly state, we do continue to reserve the right to, or not the right, but we continually have the practice of updating our scoping, and we have been thinking ahead already to the trustees and pulling in Mr. O'Brien and any other trustees. This doesn't go, Commissioner Maynard, to exactly your concern, but it's my expectation that trustees in this particular trust would be pulled into the scoping process and be designated as qualifiers.
So I just want to point out, we have two requests in front of the commission to de-designate Christopher Carney and to de-designate the trust, because the trust no longer owns the 40% stock of MGA. That was the whole purpose behind the request to withdraw, is to, Mr. Maurizio was saying, was to remove its financial interest as a stockholder in MGA, which is we have done. Commissioner Maynard, if there's a separate issue regarding, I guess, some concern regarding the overlap between an MGA officer and the trustee of the Christopher Carney Subchapter S Trust, we are prepared to try to address that by essentially making a change now in the trust, which would no longer be a qualifier.
And I understood that, and I kind of understood when the chair was talking about it's not a hang up for her, but to me, a severed relationship, to me, leaving one human being being a link in the relationship is problematic. And so that's all I'm saying. And even after, this situation goes, because I think, again, it's a leap of faith, right? I mean, your whole request is at the end of the day, a leap of faith. You are sitting in the room together, right? That would not be typical, of someone who wants to be removed from something, sitting in the room with the licensee. So I'm trying to join you on this, but I'm trying to do it in a way that makes sense going forward.
Commissioner Maynard,
Let me just jump in. Joe Capucci has waved his hands a couple of times saying he'd be very happy to resign as trustee.
Yes.
So if we would very easily do that, put in a new trustee that has no position with MGA at all. Easily done.
Thank you.
Yes, we would, and MGA stands by that as well. Obviously, on the end of, we would also not want Mr. Capucci any longer to serve as the trustee of the trust, and we'd be happy to incorporate that in, certainly maybe to the request to withdraw potentially of the trust, or however the commission wants to incorporate that into this process. Commissioner Maynard, we would make that happen. We would just need probably a limited amount of time in order to do that, identify a new trustee.
Commissioner Maynard, a practical solution, right? Does that help you on 215.02.2 on the business associate? Because you were the first to chime in on it.
Yeah, that was my hang up, and I'm appreciative of the licensee understanding that.
Okay. Commissioners.
What I have been torn with, Madam Chair, throughout this process is the fact that I have to look at what's in front of me. And the discussion that we just had was great. But what's in front of me today is that relationship is in place. And what could be happening in the future doesn't help me when I'm asked right now, is there other qualifiers? And the fact of the matter is the relationship that Commissioner Maynard just brought up as of today, as of what's in front of me to vote on or discuss, tells me that there is a relationship, a business association under other qualifiers. Would I be happy with the change that's been proposed? Absolutely. And I think it should happen. But I'm being asked today to disqualify him as a qualifier under 2, when, as of today, there is a relationship that exists with the trust and MGA. So I need somebody to help me work through that.
Commissioner Hill, maybe.
Attorney Nozzle, yeah.
Sorry, if I can start. Again, I think we're reacting to a concern that the commission is raising in connection with the withdrawals, as from my perspective, as a condition. You're not being asked, to decide on just exactly what was in front of you. You're saying, and I think what Commissioner Maynard is saying is, should this change take place, and I don't want to put words in any commissioner's mouth, then I think we're outside of the particular aspects of this regulation. And we are saying to you, Commissioner Hill, if that is something that is meaningful and needs to be done, we'll do it. If you would like Mr. Capucci to resign now, we can do that as well. But I think what we're saying is we can do this, and we're just asking you to make this and add essentially a condition to something to address this particular concern going forward. It's not uncommon, certainly, for any of the commission's licensing decisions to say, okay, this is what you presented. We're not 100% comfortable with it, but we would be comfortable with it if it had A, B, C, and D. And I think you're very much in your authority in order to do that. And if one of those things is you would not like an MGA officer to serve on the Christopher L. Carney Subchapter S Trust, we will make that happen.
Thank you for your comments. Thank you, Madam Chair.
And just a reminder too that, and I'm, forgive me for forgetting Joe's last name, Capucci, right? That he is, yes, and he is going under, he is a qualifier. So, at least with respect to, that particular subsection, he, it's a qualifier. I think you were probably asking more about the trust question, Commissioner Maynard. But I think there's a practical solution, but we could make it a condition. So Commissioner Hill, do you see any other issues under that particular subsection?
I do not.
Okay, Commissioner Skinner, Commissioner O'Brien.
Can I just get clarity on the exact question we're being asked to respond to?
We're looking at subsection 215.022 and
Yep.
whether you see any concerns there. You can turn to Attorney Monahan for more explanation.
Sure. That would be whether you believe that Mr. Carney has a business association of any kind with the applicant, and if so, if you believe that that means that he should be considered a qualifier.
Okay, I thought so. I wanted to make sure I was keeping the discussion orderly in my head. I've already expressed my opinion that Mr. Carney is a mandatory qualifier, just given the perception that he does have undue influence over the operation of the of MGA. So I'm not interested, however, in sort of backdooring him in under this provision of the regulation. So that I'll end that there. I'm good on this provision here. And my thinking is, as I indicated earlier, I would like to give the applicant the benefit of the doubt. I think, Commissioner Maynard's points raised relative to the trustee were good ones. I'm pleased that, MGA readily resolved that question for Commissioner Maynard. So I think we are moving in the right direction.
So I am not seeing a consensus to deem Mr. Carney a business associate. Caitlin, where does that
Sorry,
leave?
Chair, would it be helpful? I'm not sure, and maybe you feel comfortable with the possible financial entanglements piece that you've resolved that. I don't know if it would be helpful to go into executive session and flush that out.
I did mention that we had the opportunity to hear from Chief Chang and RSM on those issues. I think they were raised. You outlined them again. Commissioners, do you need, I thought I had asked, do you need more information on that? And I didn't hear a response of saying yes. Do we need to revisit?
If you didn't hear a response from me, I'm sorry about that, but that's just one of the many questions that I have in terms of the other information that came out about the other sort of the company that's sort of a co-presence in parimutuel and racing. To me, that's just another example of what I think why this request is premature and why he's still a qualifier.
If there's something to be said, and whether it's executive or public, I want it to be said. I don't want the record to have anything left unsaid. So if I'm hearing IEB,
Yeah, I think Chief Chang and Senior Enforcement Counsel Hall could just flush out that area that was touched on in the first executive session, but just so you have a full picture, it may be helpful. I don't think it will take long.
Commissioner, all right. Commissioner Hill, how do you feel? Do you want to revisit?
financially, I'm all set, but if other commissioners have questions, I certainly would never not want them to get their questions answered.
Commissioner Skinner?
Same. I'm interested in having, some additional, discussion, if that would be helpful to my fellow commissioners.
Okay, so in order to go into executive session, I do have to read into the record requirements under the open meeting law, and I know it's getting very late, so I'm cognizant of the fact that probably we need a break. But let's just get this attended to. The commission anticipates that it may meet in executive session in conjunction with its review of the application in accordance with GL Chapter 38, Section 21A7, and GL Chapter 23N, Section 6I, to consider information submitted by the applicant in the course of its application for an operator license that is a trade secret, competitively sensitive or proprietary, and which, if disclosed publicly, would place the applicant at a competitive disadvantage, and or GL Chapter 4, Section 726C, the privacy exemption to consider information submitted in the application materials related to named individuals, the disclosure of which may constitute an unwarranted invasion of personal privacy. Do I have a motion? And I'll just get a nod from Councilor Grossman. Are we all set on that motion?
The motion sounds good. I think we should just be clear what we're going to talk about. Financial entanglements I got. I'm not really sure what else we're going to be talking about or what the entanglements exactly are that we haven't already talked about.
There were a couple matters that were deemed appropriate for executive session the first time. We wanted to flush that out a little bit more to make sure that there's a full picture of some ownership interest, trust-related ownership interest.
I must caution about the word entanglement because I'm not sure if that sometimes could have a negative connotation. So I just want to be very careful and neutral, but there are financial relationships, financial transactions that you want to address. I think that Director Lilios did list them in her earlier comments. You alluded to them.
I believe I did, Chair. I believe I talked about an interest in the Taunton Dog Track and an interest in holdings that could lead to interest in a significant land sale.
So Councilor Grossman?
I believe we have spoken of those things in executive session, and if those the two things we're going to talk about, then that would be appropriate.
Okay, with that advice, do I have a motion?
Madam Chair, I move that the commission go into executive session for the reasons delineated by the chair and for the matters further clarified by Director Lilios.
Second.
Any further discussion? Thank you for the motion, commissioners. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
I vote yes. 5-0. And before we go into, we will return to public session, but we probably all need a break, right? It's been a long day, and I thank everybody for their patience. It's 1:30. Do you want a lunch break now, commissioners?
Yes, please.
We return, can we do 2 o'clock or 2:05? My apologies to those who are on vacation. You are working hard today, so thank you. We'll return, we'll go right straight to the executive session. I'll have Dave and Mills will transport us to the breakout room, and we'll convene around 2:05. Thank you very much. think we can take down the slide. Okay. Okay. Commissioner Skinner's here, and you may have there your video. There we go. So this is a reconvening of the Massachusetts Gaming Commission, and we just had a lunch break and a short executive session. And now we're returning to our public session. We're holding this meeting virtually, so we'll do a roll call. Commissioner O'Brien.
I'm here.
Commissioner Hill.
I'm here.
Commissioner Skinner.
I'm here.
And Commissioner Maynard.
I'm here.
Okay, so we'll get back to our where we left off, and I'm going to turn to Attorney Monahan and Attorney Grossman to just put it back in perspective. I think we were looking last at 215.02.2, and there was a question around some financial arrangements.
Yes, so I think at this point, it's up to the commission whether it determines that Mr. Carney is a qualifier under 215.022. And then once that decision is made, we can talk about next steps.
Okay. Before we went into executive session, I don't think I had a consensus or a majority on going in that direction, but I want to revisit it, given we just had an executive session. Commissioners, just help me out if you want to let me know if you think that under this more discretionary cause, we wish to deem Mr. Chris Carney a qualifier as a business associate. Commissioner.
It doesn't change my view that yes, we should.
Okay.
It didn't change my view. No, we shouldn't.
Okay.
It didn't change my view either. Director Lilios mentioned the issues that we just discussed in executive session earlier today. And it's still my opinion that Chris Carney is a mandatory qualifier under 215.02(1)(a)(4).
And with respect to, given that we recognize that that didn't prevail, you haven't changed your mind. I think you said 022.
I haven't changed my mind. I think he is a mandatory qualifier. And as I said earlier, I'm not interested in backdooring him in under 215.02(2).
Thanks. I just want to make sure I was clear. Thank you. And then Commissioner Maynard.
I think given what we've learned today and the applicant's willingness to work on that trust document, I would say not a qualifier as of right now.
Okay. I know, and I'm in the same position as I was, which is at this point, not a qualifier. So, and we then, next steps.
Sure. So having determined that Mr. Carney is not a mandatory or discretionary qualifier, the commission will need to decide whether there is good cause for him to be removed as a qualifier. And that, again, is very discretionary. You can make that decision. Once that decision is made, if no, obviously we're done. If yes, you would want to consider whether there's any conditions that you'd like to place on the granting of a withdrawal.
And this is pursuant to 205 CMR 213 now?
Correct.
I don't know if everybody wants to reference that, but that is, the requests were made via both Mr. Nozel and Mr. Maurizio.
Uh, 213, what section?
There's only 01, but there are 4 subsections, and each one is meaningful. I think Caitlin can walk us through it.
Sure.
I think
So 213, basically the relevant sections here are 213.01 subsection 2, sets that good cause standard, and it doesn't really say anything else about good cause, just that a finding of good cause is necessary to allow the withdrawal at this procedural posture. And then 213.0 and subsection 3 says that if the commission agrees to grant withdrawal under any of the circumstances in 205 CMR 213.01 subsection 2, the commission may condition that withdrawal with appropriate terms it deems necessary, including but not limited to a period of time within which the applicant may not reapply.
Commissioner Hill.
Madam Chair, so I had said this earlier, that the request for withdrawal I can be supportive of, but I would be putting some conditions on that withdrawal. And just for discussion purposes, there are 3 that come to mind. And I would just need some help on how to word it and certainly write it. But the first is the ability to influence the operation. And that would include communication with staff at the new facility. That would also have to do with communications with family members who are involved in the new operation. Certainly, I would say that it could not be an officer or a director in the future in regards to this facility. And then certainly financial ties in regards to loans, trust issues, as we've already talked about today. So those would be my 3 big concerns that I would have to be part of any withdrawal that the commission would grant. So I always try and start the conversation, and then hearing from my other colleagues is always beneficial, but that's where I'm starting at.
Commissioner Maynard?
I would join Commissioner Hill on each of those. I appreciate them mentioning the past. I also would condition it, because this is his request for withdrawal, on him not holding himself out to being a decision maker or a controller of this entity at all. So that's the first piece, and I would join Commissioner Hill. I would probably put some strong language in there, and also I kind of would like someone to monitor this and make sure that he is actually withdrawn.
Well, I echo some of those conditions. I raised a couple earlier as well. I think in terms of monitoring, I'm interested in that and exploring that. I also know that one of the hooks, of course, is to make it through MGA, right? That they understand that should they get licensed to operate, and there's any non-compliance with respect to this withdrawal of Mr. Carney, Chris Carney altogether, there would be consequences to that. So I think that's also important that we frame it that way. I think you alluded to that earlier, Councilor Grossman. That I think I've heard that Mr. Chris Carney is, willing and wants to comply with these kinds of conditions. But I think your point, Councilor Grossman, is that we would have no control over Mr. Chris Carney after the fact, so it would really have to go through MGA.
Yeah, I think we'd have to write this out, but the condition I think you'd essentially want to put in place would be that no officers, directors, or members of the staff of MGA shall have certain communications with Chris Carney, and that to the extent they do, that they be minimal and non-substantive, and certainly unrelated to the operations of the enterprise or the future of the enterprise. And what the commission did in the past when it considered a similar situation is that it directed their counsel to notify the commission promptly if there are any such communications. And that's how we've monitored the other situation. And so it's not that Chris Carney has to agree to that, it's that the applicant has to agree to that.
Councilor Grossman, explain to me again, I'm sorry, why Chris Carney would not have to agree to that? I mean,
Well, if
is
he's
the
out,
petitioner, but he is the petitioner.
Yeah.
And as a condition of withdrawal, should the commission approve that, this is, what we've laid out, or the beginnings of what we laid out, need to be met in exchange. So help me understand how, there's no responsibility or accountability on the part of Chris Carney there.
well, I guess the point is that conceptually what you're saying is that he's out, he's gone, he's no longer affiliated with this company.
With certain conditions.
Yeah, with certain conditions. But the
And so
condition,
therefore, if he doesn't meet those conditions, how is it not this commission's within this commission's authority to address that?
you can address it and you should address it, but there's nothing you can do to him.
Why couldn't you make it conditional that the withdrawal is then null and void and he's back in as a qualifier?
That's right.
But that's really a condition on the company, I would say, that their qualifiers would have to be adjusted. It's not really a condition on Chris Carney.
I'm not sure I see it that way. I mean,
Yeah, it would vacate the order and then he's back in the status of having to request again.
That's right.
I would further obviously I'm opposed to not having him be a qualifier, but I would further require that he fully cooperate with any efforts by IEB to talk about his historical involvement with MGA as part of the suitability review.
Well, again, you can impose whatever conditions you want on Chris Carney. The question becomes what happens if he doesn't comply with them. There's not much you can do to him. All you can do is take action against the company.
Well, but his status could be reinstated and that might put the company in a different posture too, but that would put him back within the purview of this commission.
Yeah, I think we're saying the same thing, but going about it in a slightly different way. So I think ultimately, if Chris Carney and the applicant are agreeable to that understanding, we can certainly craft a condition that accomplishes that.
Yeah, Councilor Grossman, I hear what you're saying, except I do want to have Chris Carney be bound by these conditions as well, and not just leave it to MGA to agree to them. I think Chris Carney affirmatively, and as part of any written decision that is issued by this commission, that needs to be clear.
I agree. I think we can make it very clear. I think ultimately the exposure is that if he disregards this and talks to employees anyway, and talks to his father and talks to the directors and officers, then the whole license, if it's issued, is placed in jeopardy.
Understood.
I might add that I agree with that. I don't know if it means automatically he becomes a qualifier. That would be, I think it would be, and I'm just trying to be fair here, if he's out, if that whatever facts involved, if whatever violation it is, then we'd be back at determining whether he's a qualifier now.
But it would put him back
would be
in that
IEB.
posture.
IEB would make that determination, right?
Well, it says if, and this is looking at the reg, it says under 3, if the commission agrees to grant withdrawal under any of the circumstances, the commission may condition that withdrawal
Right.
with appropriate terms it deems necessary. I interpret that to mean the order is conditional, meaning if any of those conditions are violated, the order goes back to its issuance, which means he is back being a qualifier. He and the trust are back being qualifiers, and they would have to appear back in front of this commission.
And I share that interpretation. How the matter, if should it come to arise, gets to the commission to hear is up for discussion.
Right.
But
I
I
agree.
do think it's this commission's jurisdiction to review that. matter.
Attorney Nozel, are you interpreting 21301 subsection 3? I know you raised that withdrawals could be subject to conditions as well.
We would agree withdrawals can be subject to conditions. I think the point at the end of the day is that the responsibility and the jeopardy is going to lie with MGA and its license. How you get there, if you want to take this step of deeming him a qualifier, and we have to go through this process again, as opposed to MGA has violated a condition of its preliminary suitability and deal with it that way. We're open to how the commission wants to proceed on that front.
And if I may say so, as counsel to Christopher Carney, whatever Commissioner Skinner would like to see along these lines, he'll be more than happy to agree to it. He has no intention of breaking the promises that he's made to the commission over these past couple of sessions. He was never involved in the past. He won't be involved in the future. And whatever the commission wishes to have him sign or agree to, so long as it follows what we've been talking about, he'd be more than happy to do so.
Well, I would certainly hope that what I'm looking for is also agreed to by Chris Carney.
I'm sorry?
I noticed my name was noticeably absent from your representation, so I'm curious as to condition number 5 that I just put forward in terms of being fully cooperative with IEB.
Oh, yes, of course. I was paying attention to Commissioner Skinner, who I think I heard last, but it goes with the entire commission, whatever, and yourself as well, Commissioner O'Brien, whatever the commission pleases to feel comfortable that Chris Carney's not going to be involved in MGA's operations, he will agree to. And he will certainly cooperate with the commission on any questions you may have as you go through this process.
More pointedly, IEB and the commission.
Yes, of course.
And I know the commission has spoken already about the monitoring of any conditions that you might adopt. It would be helpful to the IEB. I mean, typically, we're in a self-disclosure arena. And we monitor through disclosures and also through monitoring, compliance committee minutes, audit committee minutes, and that type of thing that may not be fully operational yet. So to the extent that the IEB is very clear about its obligations on this monitoring piece, that would be helpful to our team.
Director Lilios, I'm glad you weighed in on that particular piece. I had another question generally, and that is whether the IEB sees any additional conditions helpful if the commission is inclined to grant the request to
If
withdraw.
we could just, I'd like to just bring this back to, I'd like to hear from all the commissioners and see what each commissioner, if we could just have an accounting of the conditions that have been raised so far, that would be really helpful. Do we have those notes?
I do. They're a little rough, so I'll have to get the wording exactly right. But the first was a condition regarding the ability to influence the operation, including communication with staff at the new facility and communications with family members involved in the new operation. The second is that Mr. Carney could not be an officer or director in the future. The third would relate to financial ties. I think closing some loose ends regarding loans and trust issues that have been discussed here today, which I believe would include having a independent trustee assigned in lieu of the trustee who's currently the director of the company. And the next condition would condition Mr. Carney not holding himself out to be a decision maker or controller of the entity at all. The next would be some kind of monitoring of the conditions, and I'm not sure exactly where we landed on that.
I think Councilor Grossman suggested that in the past, we've had the counsel from the entity. Councilor Grossman?
If the commissioners agree, absolutely, we can.
I mean, that was just what you had, I just was reminding us for the record that that was one suggestion. Okay.
I'm just going to make a note here as we go, sorry.
The only other thing I would add for clarity on that would be that there be an obligation on the part of the decision makers at MGA to report that to council, because the situation we had in Steve Wynn was a little different, where we were telling the licensee you had an obligation to call us if person X had reached out to you. This may happen that he represents himself outside direct communication with employees. So if they come to learn of that information, I think it should be clear that the responsibility is on them to call council to then inform us if they come to any sort of information that he's made representations publicly that he represents MGA.
Okay.
Okay, I have that written down. Give me a second as I go through notes here. That Mr. Carney fully cooperate with the IEB regarding historical actions with regard to MGA. And I think that's it
Yeah.
for now.
I'd like to add that I think we've got it covered that he can't try to influence the operator through communications either in the public or, a perception by expression in the public. But MGA also it appears that they've used him sometimes informally as an agent to public agencies, sometimes informally to do work at the facility, that those informal arrangements, even though they're not controlling arrangements, be curtailed. So that means that MGA wouldn't be able to authorize him to represent him in various capacities. So it's not so much on Mr. Carney, but also on MGA.
Madam Chair, I would just add, and it's as the commission may please, but for example, as the commission's deliberating, are you proposing that, for instance, Chris Carney's company that snow plows the whole property would not be allowed to continue to do that? If that's the way the commission is going, we would need to know that just for clarity.
And right now, you have his company marked down as a vendor. And that was a question I had, like, what does that mean for status in terms of his company doing that kind of work? Because right now, I know on Friday, Commissioner O'Brien asked about contractual arrangements versus those informal arrangements. And those informal arrangements have caused confusion, right? So we want to address what has caused this confusion. And so certainly the informal. Now, the more formal, the contractual ones that he's engaged in, how do we feel about disturbing those if it's in the construction or snow plowing vein as a vendor?
Madam Chair, I envision no contact whatsoever.
Mm-hmm.
You start to get into the business association piece, and all of these things bring him dangerously close to the line, if not over it. And I would say that if he's going to be out, then he's out. If he's dancing around it, then they're playing with fire, it sounds like.
I only bring up the question just for clarity. We're more than willing to do whatever the commission wishes.
I think
I
I
think
would like to see all ties severed, Madam Chair.
A bright line, I think will benefit the circumstances. Am I wrong, commissioners? I've got Commissioner Hill, Commissioner Maynard, how do you feel? Commissioner Skinner, Commissioner O'Brien. Commissioner Maynard?
Yeah, I mean, I'm sitting here thinking to myself, do we then start looking at every contract, right? What's the, was this really high payment for a snow plowing job, and then all of a sudden we're out of gaming commission world at that point. And so I think to Director Grossman's point, the cleanest thing here is just to sever the business relationships.
Commissioner Skinner, Commissioner O'Brien. I think the three of us have sort of said.
I
Commissioner
agree.
Skinner.
I agree. The cleanest way to do this is just to sever all business ties. You know, not doing so would open, I think, too many doors. And as Council Grossman said, it's dangerously close. So.
Okay, Commissioner O'Brien.
Yeah, I mean, I think this condition evidence is why I don't think he should be, deemed no longer a qualifier. But I think you would have to include the language directly or indirectly to make sure you don't have a beard coming in where we find out he is in fact being a vendor through some third company. So I would add that language in to make sure that condition is really complied with.
Right, so I think the angle is both ways. Mr. Carney is, we don't want him to do certain things, but MGA's got to also rely on others for that informal stuff as well as the formal. Okay. Other conditions, I know that Commissioner Skinner, you've asked IEB, but then I would also need to turn to MGA, and I'm just trying to keep this meeting under our control for a second. So I want to exhaust the commissioners. Any other? Condition. It is. Okay. Commissioners, do you want to turn to IEB and MGA for further input, or are you satisfied right now?
Chair, I've already expressed my interest in doing that. So if we could please proceed that way, I'd appreciate it.
Okay, Director Lilios, why don't you give us your ideas, and then we'll turn to MGA.
I really don't have direct suggestions on what conditions to adopt here. The monitoring pieces of concern to the IEB. I know there are those other businesses, or at least Patriot Recycling, that is on the property now. I'm not exactly sure what the arrangement with MGA is with that business. I believe it may be a tenant, for instance. So I don't know if you want to address some of those relationships now, or if they would be encompassed in your general condition on, no direct or indirect relationship. But it sounds like your directive on being out of the business as a qualifier is that you haven't put any time constraints on that. It sounds like that is an open-ended thing. So I'm in agreement with that. But other than that, I don't really have any comments at this time.
MGA, do you have any further suggestions on the conditions that we've just outlined in IEB's comments? Anything that you want to add?
No, we would just ask the commission to vote on the withdrawal so that we can, with the conditions, and so we can move forward.
Thank you. Okay, Commissioner Skinner, anything else? All set?
All set, Chair. Thank you.
Thank you. Commissioner Maynard, Commissioner Hill, Commissioner O'Brien. So,
Quite frankly, the only thing I have to say on that is, some of these conditions, if there is a generational shift in ownership and control, we don't have any sense of what the succession plan is. They may run smack dab into conflict with these conditions.
So I just want to, before we turn to a vote, I guess I just would like to add a comment that addresses comments that were raised. Is that one, very, very pleased that this was a very thorough discussion. We spent a lot of hours, and I respect that. And it's been noted that the law of Massachusetts, and this is in our Wynn decision, affords the commission significant breadth in our decision making. But in that same decision, we also say, with that comes an equally significant duty of fairness. And I think today there's been a lot of time and effort to do just that. I respect the work of IEB so very much. I also respect the work of MGA and appreciate very much the submissions made by particularly Mr. Nozel. And so all that came before me informed my decision making, and I appreciate everybody's efforts. Commissioners, before we take a vote, do you want to have anything to add to that? If not, we would need a motion regarding, and Councillor Monahan and Councillor Grossman can help us, the request for to withdraw with respect to just Christopher Carney. This does not address the subchapter S trust.
I think it can be a fairly straightforward motion, something along the lines of, I move to allow Mr. Christopher Carney's motion to withdraw as a qualifier with the conditions discussed here today.
And is that, Caitlin, is that pursuant to 205 CMR 213.01 subsection 1?
So subsection 1, let me just look at it so that we're looking at the same thing. It would be, I think, it just pursuant to 213.01 subsection 2, which allows the commission to make a express finding upon good cause that the withdrawal request can be approved.
Would we need to reference subsection 3 for conditions?
I don't think you need to reference the statute in the motion. When we write up the accompanying decision, of course, we'll include any citations.
Regulation, I think, what if you just generally reference 213?
Sure.
Then you
can't hurt.
With that said,
Now I have to try to remember what I said all over again. So something along the lines of, I move pursuant to 205 CMR 213 to allow Mr. Christopher Carney's motion to withdraw as a qualifier with the conditions discussed here today.
Commissioner Maynard?
With that said, Madam Chair, I move pursuant to 205 CMR 213 that Mr. Christopher Carney motion for withdrawal be granted, subject to the conditions discussed here today.
Second.
Any further discussion? Okay. Commissioner O'Brien.
Nay.
Commissioner Hill.
Aye.
Commissioner Skinner. Aye. Commissioner Maynard.
Aye.
And I vote yes. So 4-1. Okay. Now we have the next request, which is on the trust.
Yes, and so I would suggest that we go through the same process and walk through, sorry, I got to pull up my notes here, and walk through the mandatory factors, then the discretionary factor, and just proceed as we just did.
Okay.
So I will, if you agree, I will start with the mandatory factors.
And that's back to 215.02.
We're actually starting with chapter 23 and section 5B.
Oh, that's right. Thank you.
Okay, so if we're ready, the first factor is a person who owns 10% or more of a corporate applicant let me read the preamble. For the purposes of this chapter, the following shall be considered to have control of an applicant. A person who owns 10% or more of a corporate applicant, provided, however, that a bank or other licensed lending institution that holds a mortgage or other lien acquired in the ordinary course of business shall not be considered to have control of an applicant. Okay, I'm going to move on. Second factor, a person who holds a beneficial or proprietary interest of 10% or more of an applicant's business. Okay. If an applicant is a corporation, the A, president, B, chief executive officer, C, chief operating officer, D, chief financial officer, E, treasurer, F, secretary, G, each inside director, and H, chair of the board of directors. Okay. We're then going to move on to the regulation and those factors, which is 205 CMR 215.02 subsection 1. I'll give everyone a second to get there. And that states that the following persons shall be required to qualify as part of the sports wagering license review. If the applicant is a corporation, each officer, each inside director, any person owning or having another beneficial or proprietary interest in 10% or more of the common stock of the applicant or holding intermediary or subsidiary company of such company. And in the judgment of the Division of Licensing, after consultation with the Bureau, any person with significant and substantial responsibility for the applicant's business under the jurisdiction of the Commission or having the power to exercise significant influence over decisions concerning the applicant's operations in the Commonwealth. Okay, I'll move on unless anyone has anything to say.
Okay.
Okay, great.
Now let's just take an affirmative check. Does anybody think any of those apply in this circumstance? Commissioner O'Brien.
So I'm just looking at finding good cause and substantial evidence. And where I'm hung up on this one is I think it's a very different spectrum. It's easier to segregate out both historically and prospectively. But I still have a lot of questions about inconsistencies in the presentation. And for that reason, I'm not convinced that good cause exists to remove the trust either.
Can you apply the reg? And just so I know, is there a standard on good cause? Is it substantial evidence or?
It
is?
I think, yeah, generally in lieu of a explicit standard, it's good substantial evidence.
Thank you. And that's what I applied in the last time, but I meant to ask it. And so when she just raised it, I wanted to confirm. Thank you.
So,
can you, yeah, so significant and substantial responsibility for the applicant's business, either or, Commissioner O'Brien, so I understand your thinking.
Maybe I'm going a little forward, but I'm looking at the motion to withdraw. And I just feel like I have some more questions about exactly what the financial interplay is and influence on the ultimate discharge of the loan, the financing of the company, et cetera. And so I'm not satisfied in the record before me that I can say that I found good cause and substantial evidence, whether that falls under 213 or whether it falls under 215. I guess remains to be seen, but
there is one more factor. If I just wanted to state that one, if there's any discussion of that before moving into the final discussion. So the last factor is the discretionary factor, 205 CMR 215.02 subsection 2, and that's that the commission may, in its sole discretion, require other persons who have a business association of any kind, the applicant, to undergo a qualifier review and determination process.
So I guess I was doing what we did before. Did we find that it was required to be qualified under 02 subsection 1A4?
right. And I'm not there. I'm down at the discretionary.
Oh, okay, that's helpful.
Yep.
So are we in agreement that not a person required to be qualified? Yes?
I agree with that.
Thanks, Commissioner. Okay.
Yes.
All right, that's really helpful. Okay, so now to the discretionary. And I'm in agreement too, just to be clear. Okay. And Commissioner O'Brien, you were I know you're waffling between, and not in a bad way, because it's easy to see where you're going. 02 subsection 2 versus right straight to the 213.
Correct. And it circles back to what I said before in terms of the sequence of the disclosures, the self-reporting, et cetera. When I look at it, I'm just not satisfied that the trust is not somehow still interrelated with the financing, et cetera. Acknowledging that there have been conditions just put on the other license that address some of the concerns that I had about trustees, et cetera. But I'm just not there yet to say that we shouldn't exercise our discretion given what I see as an integrally intertwined series of family businesses and trusts.
Does anybody want to follow with a question for clarity of Commissioner O'Brien? Want to give MGA the opportunity to respond. Okay. Not hearing a response. Understood.
In that
Sorry, Chair.
case,
Sorry, Chair, we couldn't get to the mute
I
button.
was missing the mouse here.
I couldn't tell. Thanks.
The principal condition, as we understand it, and the trust is more than happy to follow, is that there will be no trustee of the trust that's also an employee of the applicant. And we fully agree that that will be a condition that will be met.
Were there any accounts receivable? I'm trying to remember, or was that all under the other, under Chris Carney individually?
There's nothing with the trust.
Nothing with the trust.
No.
As it relates to MGA, correct?
Still fighting with the mouse. That's correct.
Director Lilios?
No, this is just going back to what we talked about in executive session, but I agree with Mr. Maurizio.
okay, if the commission is of the opinion that the trust is not a mandatory or a discretionary qualifier, then it would move on to determining under 205 CMR 213 whether there is good cause for the withdrawal and whether there are any conditions that the commission would like to apply. And of course, Mr. Maurizio just pointed out one, which is that no trustee of the trust would also be, an employee, director, or director of the applicant.
Do we need to add family member to that list?
We can.
We should, I think. I just, I didn't know if the rules of trust estate speak to that already or not.
We just have to be careful about how we determine what a family member is, because the applicant is a corporation, and so a family member it's a little bit different. So you could say no relation of the Carney family, I suppose.
Yeah, exactly that. Thank you.
If I may, if the Carney family member has no connection to MGA, I wouldn't understand why that would be a necessary condition. It seems to me that the first condition, which is no one who's an officer, director, shareholder, or employee of MGA shall be a trustee, I think would cover the complete severing of the relationship between the trust and the trustees and the applicant. But as an example, if Chris Carney's mother wants to be a trustee and she has no connection to MGA, I don't know why that would be a problem.
The concern I have there is the level of influence, again, that might be at play in the relationship between Chris Carney and his mother.
Okay, if you want to list his mother or some specific people, it's not important to the trust. I'm just trying to keep this in line with the commission's thinking, as I've heard it, that there should be some business association between the trust and the applicant. And, but if the commission wishes to put on, some other controls that it thinks is necessary, we're not going to, at this late stage, debate that. We're trying to be completely cooperative, give the commission all of the assurances it thinks it needs, so we can move on with the application. So whatever the commission pleases, we will do.
So
I don't want to list out, I'm sorry, Commissioner O'Brien. I don't want to list
the
out
circles of
specific-
consanguinity for our enhanced rules. Can it be something like that?
Can you say that again?
We have circles of consanguinity that you can have conflicts. You can only go so far out. That's usually how it's written in terms of when you look at ethics restrictions. So
Are we Are we,
You could
before
pull
we
a
go down that,
narrow
can I
circle.
take a temperature check on the other three of us to see how far we want to go with this? Commissioner
Um,
Maynard,
I was thinking similar to Commissioner O'Brien, really thinking of family members who may be beneficiaries of MGA.
Right.
If he's got a second cousin twice removed who's a really good trustee, I wouldn't want to keep that person from being able to do it. So more in line with Attorney Maurizio and Commissioner O'Brien's thinking.
Commissioner Hill?
Along the lines of Commissioner Maynard, may I suggest that the commission identify a family member that would not be a trustee, or a person that would not be a trustee, is anyone that has been a shareholder of MGA, an officer or director within X amount of years. Give us a time period so we know what to look at. If you want to put a 10-year time period from today, 10 years to the past, something like that. Now we have a very clear structure to understand and comply. We won't have to worry about a second cousin type of situation.
And I'm sorry, would that include anyone who does have a financial interest in MGA?
Oh, absolutely, absolutely. Look, the trustees, if I may, from what I'm hearing, the trustee of the trust will not be an officer, director, shareholder, or employee of MGA. Nor will it be a person that fell into one of those four within the past X years from today. That covers a whole lot of people. And there's a public record that shows what that is. And then, as Commissioner Skinner just said, because there may be somebody theoretically tomorrow that could come in and have a position. And so you could add an additional covenant that says, or condition that says, and no one who becomes an officer, director, shareholder, or employee of MGA will become a trustee of that trust on a going forward basis. I think that covers everything as far as I can think.
As long as that list excludes someone who has a financial interest in MGA, I think I'm good with it.
It does, because you have to be a shareholder to have a financial interest or pull a paycheck, so to speak. And I think that covers both worlds.
Well, what, I mean, I don't want to go too deep, but what about survivors' rights
Right.
and things like that? Could you speak to how that works? Because it's definitely something that comes to mind when we're talking about George Carney's mother potentially becoming trustee.
Yes, well, I think the conditions the commission has outlined are also prospective. So they don't change, those conditions don't change just because circumstances involving Mr. George Carney or anyone else may change in the future. Those are conditions. So if a trustee who becomes a trustee tomorrow, for example, decides to retire and move to wherever, and we need a new trustee, your conditions are still in place. We would have to designate, or the trust mechanism would be looked at to designate a new trustee. When it comes to the flow of the stock certificates, I would point out to the commission, who has the bylaws, I understand, there's a restriction on transfers of shares. So the board of directors of MGA have to approve any transfer of ownership of those shares. And those directors of MGA are completely under this commission's control through the licensing process. So, you know, the shares can't move by order of the probate court, for instance. They have to go through the board of directors. And in fact, there's a very old SJC case again that upheld MGA's stock restrictions. the validity of those tax restrictions. So they're very strong, they're valid, and it's all under the control of the directors, which is why if you look at the corporate papers that we submitted, the votes, it's all covered in those votes, the transfer of the shares, because it's a requirement under the corporation's bylaws.
Thank you, Mr. Maurizio. I'm going to turn to Councilor Grossman and Councilor Monahan. You've heard the sentiments of the commissioners and Mr. Maurizio's recommendation. Are we close in terms of a condition?
Yeah, I'd want to do a tiny bit of wordsmithing, but I think where we are is there shall be no trustee of the trust that is also an employee, director, officer, shareholder of MGA, or anyone who has held one of those positions within the last 10 years. And I would, of course, in wordsmithing this, just make sure that it's basically talking about anyone who's held this position in the last 10 years, currently, or sort of in the future. If they start to hold that position, then they can't also be a trustee of the trust.
Is there any other limit that you'd want on the appointment of the trustee? Okay. So that's one condition. The other condition,
Sorry, excuse me. That was the only condition I had on this one so far.
felt like we had another one, but I guess you're right, Caitlin. My apologies. I need just 2 seconds. My apologies. So we have that one condition. Is there any other concerns? And this would be again to permit the withdrawal of the subchapter S trust. Okay, are we prepared to move then? It'd be a similar motion that we used.
I would suggest that it's the same motion, but replacing Mr. Carney with the trust. Would you like me to say it again?
So I just want to make sure that it's 215 and not 213, Caitlin.
It is 213, 205 CMR 213.
All right, I thought I heard 215 earlier. Madam Chair, I move that pursuant to 205 CMR 213, the Christopher J. Carney Subchapter S Trust motion for withdrawal of application as a qualifier be granted subject to all the conditions discussed here today.
Second.
Any further discussion? Okay, Commissioner O'Brien.
Nay, based on me not finding substantial evidence.
Okay, Commissioner Hill.
Yay.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
And I vote yes, so 4-1 again. Okay. So thank you, everyone. With respect to that portion of our number 5, we are slated to discuss preliminary suitability, and that's critical to, I know, the applicant for us to turn to that. We have spent 2 full days on this, and I am very hesitant to roll it over. With that said, I think we probably could use a quick break and continue on. Commissioners?
Madam Chair, before we take a break, could we really just do a temperature check? I know you're hesitant to roll this over. I'm not suggesting that we do.
Yep.
But I committed to reviewing this matter today on a vacation day, and we are now 3 hours beyond, over 3 hours beyond what I anticipated. And somewhat selfishly, I would like to at least enjoy some of this day. I'm happy to excuse myself for the remainder of the meeting, should it come to that. But I want to, at least just see where the other commissioners are in terms of getting to a determination on preliminary suitability today. At least, I know where I stand. Generally, I'm interested in preserving and expanding the longstanding family and community institution that is MGA, with the appropriate guardrails in place to address some of the issues that we've heard about today, particularly around credibility and financial viability. But I don't think I can do that in good faith. I don't think I could grant preliminary suitability today in the absence of the identification of an operator who is ready, willing, and able to step in here at this point in time. So I wanted to put that on the record in the event that I'm not able to do so later in this discussion. I just, again, it's after 3 o'clock, and I've already committed time well beyond what I initially said that I would. Again, that is just to make it clear that I'm happy to excuse myself from this meeting, and commissioners are free to proceed. But I want to just get a temperature as to what the other commissioners are thinking in terms of getting to a determination on preliminary suitability today. And I say all that with all due respect to the applicant. I understand, and I think we all share the chair's sentiment that we last resort want to roll this over. But I think I want to be realistic here about what we think we can get done today.
So I have a similar concern procedural posture-wise in terms of us addressing preliminary suitability where there's no operator in place. I think there has been significant change in the status of the applicant after the votes that were just taken. And I think I said this earlier on, that another potential outcome today was to say to the applicant, this is not complete, and you have not met the threshold that we're looking for to move forward. And that's where I am right now at a procedural posture note, where I feel like, given the material changes that have just happened with the votes and the fact that we don't have an operator on a sports book, the more prudent thing from my view would be to say to the applicant, you're not complete yet, and you need to come back when you are.
Commissioner Hill, Commissioner Maynard?
I don't disagree with my colleague, Commissioner O'Brien. I said this Friday that I was trying to understand how we could move forward without an operator. My mind has not changed, and I don't know how we can move forward without an operator. We did just take some new votes that I think maybe the applicant can go back and discuss privately with possible partners, but I don't know how we can move forward, Madam Chair.
I'll jump in before I turn to Commissioner Maynard. Sorry, Commissioner Maynard, only because he asked, said, I don't know how to move forward. And actually, that's part of what I was hoping to hear today, a little bit more clarity. Attorney Nozell started today with extensive comments and explained to us how we could possibly get there. And I was hoping we could hear a little bit more before we make a determination one way or another. That is, of course, been a major factor for us to consider, but I'd hoped that maybe today, before we broke, we would know whether there is a path forward. I have not ruled out one, but I haven't ruled one in either. So I was looking to be educated. Commissioner Maynard?
I think that that the applicant is in a different posture than they were, given this. I think that it's, what I see in the record, I can say this, looks a lot more positive than it did before. And it is something that I feel is trending the right direction for sure. But absent an operator, and it sounds like there's consensus, it does make taking the temperature, which is what we use colloquially, very hard to do because it's taking a temperature without a thermometer. So I think it's very difficult to do a grade or to think about meets, exceeds, so forth, Madam Chair. But I will also state on the record that this applicant is in a much improved position right now.
Could you just say the last part again? I'm sorry, I couldn't hear you, Commissioner.
The applicant is in a much improved position from my perspective, given the decisions and they've made today in concert with us.
Well, I'm hearing that there isn't a consensus to move today. I'm disappointed personally because I don't know. I know that there are more vacation days ahead this week, and I know we have an extensive meeting on Thursday. So I'm looking to see how we get our work done. And I am quite cognizant that this has been an outstanding request for a while now. And the applicant was patient with us. If I recall correctly, it was, we've rolled this over a few times, sometimes because we needed more information, and then other times because of our scheduling. So I just want to put on the record that does this mean we are up at 9 a.m. tomorrow doing this again? 8 a.m.
I wouldn't think so, Madam Chair. I would think that given certainly my position on this, I would expect the applicant may need more time than overnight to make a determination as to whether they can come in with an operator.
Can I just be heard just briefly and maybe provide some, I guess some context for the discussion, and just really deal with sort of the practical reality without any finding or sense of MGA's suitability now, with the removal of the trust and the removal of Chris Carney as qualifiers. It still proposes a huge challenge for us to go into the marketplace after 2 days of public hearings about questions on MGA suitability and find a partner. We think we've addressed the concerns that the commission has raised, both through the removal request and now that it's been granted. And we do believe that MGA, as it sits now before the commission, meets the standards for preliminary suitability. We're not asking for anything more than that particular finding. And if it's conditioned on us needing to come back, certainly to proceed in any way whatsoever, based on having an operator in place, we are certainly, we understand that that is the reality. But right now, we have a lot of information and really no understanding of where the commission is as to MGA's overall preliminary suitability, which puts us in a really, I think, difficult position to do exactly what the commission is asking us to do, is go out, get another operator. You're not going forward without another operator. And we want to do that. We have a potential partner to do that, but that potential partner has told us they won't go forward with us unless we have some determination on preliminary suitability. So we're stuck. And And I'm not suggesting that that's the commission's fault, but that's the reality of the situation. So what we've been asking for is really a determination, very limited, that MGA, as it sits now, after all the other issues that have been brought up and that we've now responded to, so we'll meet the preliminary suitability standards as applied to Category 2 sports wagering licensees. And we would like the commission to consider and make a finding on that to allow us to do exactly what you want us to do, is find a operating partner. But it's going to be difficult for us to do with that level, honestly, of continuing uncertainty without some understanding of where the commission is and whether we want another potential operator to make the investment to come back in front of the commission in order to move something forward. So it is a unique and unexpected request, but it's one that I feel is absolutely necessary, again, for us to do exactly what the commission would like and bring us back with an operator. We need some determination on preliminary suitability in order to do that.
Attorney Nozel, I hear you in all of that. I hear the sincerity there, but where I'm stuck, and I raised this question on Friday, is understanding the intersection between 215 and 218 as it pertains to preliminary suitability with respect to the overall application. So I had asked on Friday, and Attorney Monahan gave a little bit of guidance, but how can we bifurcate those suitability determinations? I don't understand how, and I'm not saying I can't get there, but what does it mean to, if the commission is inclined to determine that MGA is preliminarily suitable under 215, what does that then mean under 218? And I'm happy to hear from you, Attorney Nozel, but the question really is directed to Attorney Monahan.
So we talked on Friday about 215 and 218, and both include, and when you're talking about preliminary suitability, you also have to look at Chapter 23 and Section 6, which sets out some of the factors that need to be considered. When you take Section 6 and 215 together, you get all of the factors that need to be considered for preliminary suitability. And then the commission makes a determination based on those factors. Functionally, that decision is then ported over into 218. They're not different standards in 215 and 218. That is ported over as a factor for overall whether the commission is going to award a license. I would say, as I said on Friday, that determining preliminary suitability requires a holistic review of the applicant and all of its qualifiers. There are several factors that I believe the commission that would relate to the operator. And so it may be difficult to sort of evaluate those factors without an operator. I would also say that earlier in the day, there was discussion about sort of a condition on the operator. And I do think that would be different from conditions that have been issued in the past on licenses. Previously, conditions are along the lines of, the applicant should work with the IUB on the investigation or things like that. They're sort of self-executing that can happen and the license moves on. This kind of condition, a condition on finding a new operator, would actually require a whole second round of suitability determinations. You'd have to go back once the operator came in. And I don't think that's anything the commission has done before. So I do see this request to be different from other requests for review of preliminary suitability and potential conditions.
Yeah, so the only thing I would add to that is really, I think what we're asking for at the end of the day is really to go through the factors under 23 and Section 6D, integrity, honesty, good character, and reputation of the applicant, financial stability, integrity and background of the applicant, the business practices and business ability of the applicant to establish and maintain a successful sports wagering option, which is the one we are suggesting the commission condition as part of its review on us finding an additional operator. And then you can answer the question of whether the applicant has a history of compliance with gaming or sports wagering licensing requirements in other jurisdictions, whether the applicant at the time of application is a defendant in litigation, and then the suitability of all the parties and interests to the license, including affiliates, close associates, and financial resources of the applicant, which obviously we've spent over the last 2 days coming up with what that is going to be for purposes of the review. So the way I envision this working is that analysis, with the understanding that, and what we've heard clear from the commission, is that it's not going to find us necessarily suitable in connection with our ability to operate a successful sports wagering operation without an operator. We understand that. We understand that you're going to do that, and you need to condition that particular finding. Again, also based on the experience of MGA and its history of wagering in Massachusetts, but also conditioned on the fact that we would still need to find an operator. If we satisfied that, we found the operator, we then come back in front of the commission, satisfying the first prong now under your evaluation of our overall application in connection with the suitability of the applicant under 218, with the first prong essentially having been established. So I think that's the way we envisioned what we're asking for to happen operationally. As we've gone through today, we think we meet those standards with all of those conditions. And that's what we're requesting of the commission.
The one response I would make to that is that when you look at the preliminary suitability of the applicant, that does take into consideration the qualifiers. And I don't think you can necessarily say that the operator is only relevant to one of the factors. I think it's entirely possible that the commission could decide that it's relevant to multiple factors. And so it could be very difficult to disaggregate without an operator. And then you would have to come back and do a full new preliminary suitability review with an operator.
Again, if any of the prongs are conditioned on having, yes, we think you do have the requisite integrity, honesty, and good character for purposes of licensing, but it's conditioned on you also having an operator. I think you can do that with each one of the elements under 6D to the extent that it's applicable. And the commission isn't, going any further than that. And if we can't come back with an operator after that finding, we're essentially done in connection with the current application.
So I hear what you're saying. I have the same mind that Commissioner Skinner does in terms of, Mr. George Carney and his history of a business and maintaining that business and going forward. But I have to say that all of the other applicants, not only in this, but in horse racing, et cetera, we've made very clear that the application is supposed to be complete and in a posture to go forward. And for me, absent an operator, the exercise of going through other things that may influence that, to me, is just not appropriate in this posture. I don't feel comfortable doing it.
Commissioner Hill, Commissioner Jordan, Maynard, I've done that twice today.
I haven't changed, Madam Chair. I don't know how we can move forward. And at this point, I'm not willing to do so without an operator.
I've been called worse than Commissioner Jordan, probably in this meeting.
My apologies again.
No, it's fine. I was kidding. A little bit of levity is what I was hoping for there. That's why I asked the question that I asked. I guess I would ask Caitlin, is it even proper, to Commissioner O'Brien's point, to whether it sounds like it's not today, Commissioner Skinner and others, but Commissioner O'Brien, Commissioner Hill, but would it even be proper for us to say, in so much as what we have, the commission, I'm trying to even figure out how we would say it. there's no issues with what we have as of right now. I guess, Caitlin, I would ask, would that be possible? Again, assuming all those facts were true, and then, to Attorney Nozel, would that satisfy what you're looking for?
I mean, I would say that that is not contemplated by the regulation, and it is more of an advisory opinion than a decision. The reg contemplates a decision and not an advisory opinion. So it is not necessarily what I would recommend. That said, if the commission wanted to do that, we could potentially find a way to move forward.
I guess sort of picking up on Commissioner Maynard's, I guess, string, and we like that determination regarding preliminary suitability, but maybe I'll ask the question in a different way. Based on the changes that have been done in front of, including the removal of Christopher Carney, including the removal of the trust, what is the commission's position regarding preliminary suitability if we were to come back with a proponent? Is that something that's, and this is what I'm concerned about, is that dead on arrival and I'm going out and finding a partner that I ultimately won't be able to get through just because of right now the suitability issues that are in front of the commission? So whether it's a sense of the commission that you're not making a final determination, but you know what, MGA, you've made a lot of changes, you've made a lot of representations, and what Commissioner Maynard says, we're in a much better position, or we're an improved applicant, or there's a more likelihood that you're going to be found preliminarily suitable with a operating partner, something that we can indicate to the marketplace that we have a pathway forward.
Commissioners, Commissioner Hill, how's that registered with you?
Give that some thought, Madam Chair.
Commissioner O'Brien?
For me, it's asking the same question in another way. With all due respect to Attorney Nozel, I still feel uncomfortable moving forward. It's not how we've treated any other applicant. In my view, it's not the right way to do suitability, certainly, and preliminary suitability. I'm just not comfortable doing it today. And that's, to me, this applicant is still moving, but not sufficient to adjudicate preliminary suitability unless and until they come back with an applicant, and then we look at everything. That's where I am right now.
Well, this category 2 application is a little bit different from the others. We can acknowledge that because it's not in the same competitive vein that we saw for category 3, and even different than category 1, because we were assessing our own licensees, where in this case the legislature has actually deemed this particular entity to be licensed to do sports wagering in Massachusetts, subject, of course, to our rules and regulations. Took a good amount of time to address the request for withdrawals. We reviewed all the preliminary suitability materials. Now we have to remember that Mr. Carney and the trust are out. And so to Commissioner O'Brien's point, it's not, reason why I'm struggling with this is because this isn't a topic that's new. Councilor Grossman, you and I talked about this, was there a path forward without putting the application review in front of us? And so we were to look at this through a narrow lens, and that's what I'm struggling with. I'm hearing my fellow commissioners say we can't, but I thought, in fact, we thought there was a path forward somehow here, but maybe I'm missing something. I just want to make sure, checking with council, I hear Commissioner O'Brien, I hear Commissioner Hill. hear Commissioner Skinner saying no, but I just want to make sure that before I leave, at least I understand why their no makes sense and make sure that you're not thinking something different, Councilor Grossman.
No, I'm not. And, the reality was that neither I nor the chair could make this decision on our own outside of this meeting. And this is the way the decision had to be made. To put it in legal parlance, I think what ultimately the commissioners are saying is that they can't get to a place where they find substantial evidence in the record that the applicant is preliminarily suitable to move forward based upon essentially the lack of an operator.
Is that what they've said though? I want to make sure.
Well, no, but if that's what, they're not taking a vote. I think that's there's no vote that's been taken, to be clear. But that's kind of where everyone is from a legal perspective. And that's what I was looking to find out what the commissioners thought about this. And I think folks have been clear as to where they stand.
So, no, I just want to clarify. So that is what they're saying, that there's a decision that there's not substantial evidence. I don't know if they're saying that or that they can't go forward right now.
Well, we might be splitting hairs a little bit.
Not necessarily.
It's not that they can't go forward. I think I don't want to put words in anyone's mouth. I think that everyone's trying to be careful not to make any final decisions, to preserve everyone's rights and futures and whatnot. And if called to a vote, we could see what happens. But I think most of the commissioners have been very clear as to where they are right now. So I wanted to get clarification that as to, I think there was a request to actually put the application on the agenda. And I thought that we really couldn't do that. So because of the issue that's presented. But then I thought I understood that we were looking at a little bit more of a narrow scope on this particular issue, but I'm hearing that without the operator in that place, we can't proceed in the way that I think Attorney Nozell just laid out. Is that fair? So I think it would be fair to say the commission probably won't get to where Attorney Nozell has proposed it get to.
Okay. Commissioners, is there anything you'd like to add for the record? Or
Chair, I'm sorry, go ahead.
No, right ahead, Commissioner Skinner. Your video's off, so I can't read the lean in so much, but I understand why you want your vacation day videoed off, so thank you.
I just wanted to clarify, it's not that I see that there's no path forward. I think that there might be. We just don't know it at this point in time. And I don't want to put the cart before the horse. To Attorney Nozell's point about, being in a position to go out into the marketplace with some I guess some a little bit of support in doing that in terms of what this commission has decided. I think you got a nod from a couple of the commissioners here in that there have been some significant decisions made in MGA's favor. And I think, the sentiment has been made that already just in that decision-making, MGM is in a much better place to go back and have discussions. I'm sorry, did I say MGM?
Okay.
I'm sorry, MGA is in a much better position than it was on Friday, than it was this morning, to then go back to have those discussions with whether it be Caesars or any other potential operator. So I support that. I do think that we've made some significant headway here, and I don't want to lose sight of that.
Madam Chair, I feel Commissioner Skinner's pain. I can actually hear it in her voice, and I join her in that we literally have a situation where our counsel, who is really, really good, is saying it's hard not to treat this as an advisory opinion. I also hear Attorney Nozel and the applicant saying we need some assurances, and so I'm struggling in the same way as Commissioner Skinner, and I also heard Commissioner O'Brien say, you know, there's an appropriateness factor here, and so I'm trying to balance on all of those, and where that leaves me in that balance is that absolutely I have watched this application come for months. This is one commissioner talking. I've watched it come for months. I've seen various iterations of it. Sometimes I've grinned and bared it when I get these emails in the middle of the night that something new has come in or something new has been done. But that said, taking everything in totality, to answer your question, Attorney Nozel, this is one commissioner talking here. Absolutely. I think that this is in much better condition. I think that had an operator been with you today, I think I could have made a decision, assuming we had information on that operator, right? IEB had already checked them, things were looking. So I feel the pain, I hear the pain, and in so much as I think all I can say legally right now, this moment is a much better application when it comes to preliminary suitability. I think the applicant has also demonstrated something else, which is their unwavering willingness to try to get to something here and to get to yes and to work with the commission, which is, you know, extremely laudable that you're willing to sit through this for 2 days, and when we have an issue come up, you've had a response and said, hey, how can we make this work? And we're going to open ourselves up to you. And I think all that should be taken into consideration from anybody that would want to do business with you. But again, I don't want to go so far as to overstep my boundaries as a commissioner and somebody who's watching the integrity of this process to try to become a piece of a negotiation tactic here. So I think I gave you the best that I can give you, given what the other commissioners are saying.
So, I echo Commissioner Maynard and Commissioner Skinner's. I had hoped that we could perhaps move forward in the vein that you requested MGA. I know that it would be an extraordinary condition. I didn't hear that it wouldn't be a permissible condition. The application with your prior operator was extremely strong. We were going through it. And I am hopeful that to the extent that they maybe knew their interest, that they do so for you. And that, you're able to come back with a strong application with the operator in place, because that seems as though the procedural process, the procedural sequence that we've got to go through. Although I like to be imaginative, think of it's hard for the commissioners to imagine how we can proceed. So what I am very concerned about is delay on our part. But I also hear, I think Commissioner O'Brien raised a good point that they're going to need some time to meet the expectations of this commission. So I'm turning to Councilor Grossman as interim executive director. How would you recommend that we proceed?
It sounds like we should perhaps, well, there's a couple ways to do it. One option would be to give the applicant some time to digest this conversation and see what they would like to do as far as next steps are concerned. The other way to do it would be to postpone these proceedings until a later date and check in as to where we are, whether there's any update for the record or otherwise. I guess both are very similar in some ways, but ultimately no final vote will be taken here today. So either the commission can set a next date
I
or,
think we've established that. I'm
yes,
just
yes.
saying, will you plan on meeting with the applicant for next steps and keep us informed? How do you want to proceed?
I see,
but-
yes. I'd be, I could certainly communicate with the applicant to kind of hash out the next steps in the process. This is a difficult forum to do that, I think. But it's very clear, the application, no final action has been taken on it. So I think we will have to make some decisions as to where we go from here. But I think if everyone's comfortable with that, we can communicate with the applicant and report back.
MGA, I want to leave last word with you.
Thank you, commissioners, and also thank you as well for certainly to providing some sentiment and I guess a reaction to sort of what MGA has done to date. We're appreciative of those comments. We're certainly happy to sit back down with staff. Obviously, I don't have an answer as to timing on next steps, or if, being quite frank, whether there will be any. But we certainly will go back out and appreciate some of the sentiment that's been given today, and obviously are thankful for the rulings in connection with the trust and Mr. Carney.
Well, I hope to see you soon.
Thank you.
Thank you very much.
Chair,
I'm trying, I am so concerned about this, but it is what it is. We didn't ever take a vote, but I heard 4 are prepared to adjourn today. Commissioner Skinner?
I just would be remiss in not communicating this. I'm whining about not getting to enjoy all of my day today, but I just want to extend gratitude and appreciation for the MGA, its attorneys, its team. You've shown incredible patience throughout this process these past couple of days. I know it's not easy sitting on your side, but I do want to make sure that you knew that that I think we all, I think I can speak for my fellow commissioners here. I think we all understand, and I don't want to make light of the situation in my referencing my vacation. I'm committed to this process. I'm committed to doing my part here, and I really do. I'm rooting for you. That's a long-winded way of saying that, but I do think we need to ensure that we are in a good space here. So thank you.
Thank you, Commissioner.
Thank you. Thank you.
And I just want to point out, Madam Chair, you had, it seemed like 3 willing to adjourn and 1 who was going back and forth, which is me, and then you who was not. So
I think we're 2, possibly. I don't think I've got a 3rd though, Commissioner Maynard. I think I wish I could get a 3rd, but it doesn't sound like I'm going to get a 3rd, and I can read the room. And again, I wish the MGA the very best in being able to come back to the commission soon with meeting the expectations of the commission so that we can move on your application. Pleased with the work that was accomplished today with respect to the request for the waivers. And we'll go from there. But Commissioner Maynard, am I right? Somebody's going to need to move to adjourn, and this is maybe one where I say nay.
I would move to adjourn, Madam Chair.
Second.
Any discussion? Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Maynard.
Aye.
I vote no. 4-1. Thanks.